file an urgent motion, my lord. Let it be listed tomorrow. Because, my lord,
What is the urgency?
My lord, my application under section 47 has been rejected. Revision is pending before your lordship.
What is pending?
Revision.
Revision against what order?
In the order, a rejection of section 47.
Yes.
Now appearing before your lordship's list. Now, my lord, police help has been allowed under
208.
208.
What is the item number in section 47? Rejection?
155.
Supplementary list.
Supplementary list. My lord, kindly let it appear tomorrow, my lord. I will hand over the number, my lord. I am filing this.
File it.
And
it will appear.
Hand over the number. Let it appear tomorrow, my lord.
Police order already issued, my lord, on 23rd July is the date fixed for demolition. It
Yes.
is included on tomorrow, my lord.
When the demolition order was passed?
My lord, on 2nd July.
When have you filed?
My lord, before that.
Before that? So it's not appearing in the list?
No, my lord. Not yet appearing.
Why? When have you filed?
My lord, on June.
June. What was the date of listing? Have you checked up? It did not appear.
No, 1802 not appeared. Not appeared.
It appears on the date we have mentioned in the presentation form. Please check up. Must have appeared.
Well, it will be included tomorrow.
Cannot be. Please ascertain, then inform, then mention. Please see what was the date in the presentation form you have mentioned. If it has not appeared, please see that.
Actually, this is transferred. Transferred.
That is neither here nor there. On the date, all matters are appearing in the date as you have mentioned for listing in the presentation form.
Okay, then I'll check up and
please check up, then mention.
Item number 1123, Your Lordship. I want to substitute the opposite party prior to expiry of the interim order. My humble prayer, Your Lordship, kindly, Your Lordship, make the matter out of the list so that I can mention before the
1103.
1123, Your Lordship.
Of the monthly list. Calcutta to be mentioned, 1123. Monthly list. Please give us list. Yes, call the list.
Number 1 with 2.
Choose these. Passover.
Item number 3.
Passover.
Item number 4.
Passover.
Item number 4, my lord, I am for the petitioner, my lord.
Yes.
Appearing, my lord. In this matter, my lord, you had once appeared for the petitioner, my lord, Your Lordship, my lord, in you were once the advocate for the petitioner, my lord. My lord, you had appeared for the petitioner in CO 1221 of 2015, my lord, in order dated 7/1/2016, my lord.
I appeared.
Yes, my lord.
Since it has been submitted that I had the occasion to represent one of the parties in an earlier round of litigation. First up, in view thereof, let the matter go out of the list. In view thereof, the matter stands released from the list of this bench. First up, let the papers be placed before the Honorable Chief Justice for necessary orders.
Thank you.
Call the next matter.
Item number 6.
Passover.
Item number 7.
Passover.
Item number 8.
My lord, this is my application, my lord.
Yes, Mr.
My lord, the written statement was already on record prior to the suit being transferred to the commercial court. My lord, despite that, my lord, the written statement has been rejected by the commercial court, applying SCG contracts, which says in a commercial suit, 120 days time limit has expired. So it cannot be accepted. No, my lord, there are judgments, my lord, which I shall place that the timelines are not applicable for a transferred suit. But I'll start with my worst point to try and, my lord, I'll try and satisfy your lordship on that.
Mr. Gupta, give me 2-3 dates when the summons was served upon you.
My lord, summons state is not there, my lord. My lord, just two things. My lord, there is a delay before the court in which before the transfer, before the normal civil court. My lord, what had happened was the defendant had taken out a Order 7 Rule 11 application.
Yes.
But I am fully aware of the law that, my lord, pendency of an Order 7 Rule 11, my lord, would not, my lord, absolve the right to file the written statement. But, my lord, be that as it may, my lord, that was what the clients were advised. And in addition to that Order 7 Rule 11, the defendants filed an Order 12 Rule 6 application also. My lord, because, my lord, before, my lord, the consumer forum, the plaintiff had filed a complaint where my clients were not made a party. There was no claim. But despite that, this was filed. So, my lord, initially, my lord, the 711 application was contested.
Yes, Mr. Gupta.
Initially, my lord, the 711 application was contested, my lord. Thereafter, it came to the High Court where it was dismissed. Thereafter, Order 12 Rule 6 was also contested. My lord, in the meantime, my lord, the time had expired naturally. But we had filed the written statement, my lord, with an application for acceptance of the written statement. My lord, the only ground, and I must be candid, there is no other ground, that it was advice of the advocates that since the issue of maintainability of the suit is pending, I need not file written statement. But I know it's completely contrary to law. My lord, I cannot improve my case. It's completely contrary to the judgments, my lord. But that is my only case in, my lord, my acceptance for WS written statement, I'm sorry, my lord, within the time prescribed. My lord, be that as it may, my lord, my written statement was kept on record, subject to acceptance. My lord,
Yes.
but the difficulty which, my lord, now I may...
Keeping the written statement of on record is neither here nor there.
Yes, I understand it has to be accepted by an order. Absolutely, my lord. But my application for acceptance was also there.
Where is
And
your
the written
where is your application for acceptance filed prior to transfer?
Yes, my lord, your lordship would kindly take the compilation, my lord.
I may file the compilation. I've already served a copy on them also.
Compilation of what?
A document.
The three applications, my lord, which ought to have been annexed, my lord, it was not annexed, my lord. Your lordship would kindly pardon us, my lord. We have filed an application, my lord.
Where is the application for extension? It's at page 33.
Yes, madam.
Yes, my lord.
33 to 55.
I'm sorry, my lord.
33 to 55 is
Yes. Kindly takes a look at that, my lord. Your lordship would find that that is the ground, my lord. There are two pending applications. Order 12 Rule 6 and, my lord, Order 7 Rule 11. Two pending applications were there, my lord. Kindly cease from paragraph 2, my lord.
Physical copy.
No, really, it's going till paragraph 5, my lord.
It is important.
this transfer took place.
Thereafter, transfer took place, my lord. That was sometime, my lord.
The dates.
Yes, my lord. 15th March 2022.
Was the transfer.
Yes. And your lordship would find from this that, my lord, may I show the order by which the written statement was taken on record, subject to acceptance, of course, my lord. That is 28th of February 2020. 2 years thereafter, the transfer happened.
What is the date?
28th February 2020. May I take your lordship to that order, my lord?
8th of February 2020, you filed your written statement.
Yes.
Along with an application.
along with an acceptance application.
Their application was never decided.
My lord, page 263 of the revisional application, your lordship would find that order by which the written statement was kept with the records, and also it also records an application for acceptance has been filed. Though in the impugned order, the finding is that there was no application which accompanied the written statement. Kindly see page 263. February 28, 2020 order. Has your lordship got it, my lord?
Yes, yes.
Yes. Receive put up application on the prayer of the defendant number 2 along with written statement supported by an affidavit and petition under section 27 read with section 151 CPC. Copy not served, let it be kept with the record. So, my lord, my written statement filed, kept with the record on 28th of February, not accepted.
Together with the application.
Together with the application for acceptance.
Yes.
My lord, now two bad points which I need to tell your lordship before I try and place my case. Prior to this, there was an order passed in an order 7 when my order 7 rule 11 application was dismissed. In that order, the suit was directed to proceed ex parte. My lord, we challenged that order by filing a revisional application before this honorable court. This honorable court, my lord, did not interfere with that order, but made an observation that we shall be at liberty to take out appropriate application, and the trial court would consider the same when we file that application, because when the suit
Yes.
because when the suit was directed to proceed ex parte, we had not taken out an application praying for recalling of that ex parte. Or, my lord, we had not filed a written statement because your lordship would see the date, that was 17th of December 2019 when it was directed to file go ex parte, and my written statement was filed in 28th of February 2020. But, my lord, when we applied before the court below, my lord, by taking out a recalling application also, this application is there, we had taken out a recalling application also of that ex parte order as well as a show cause. The court below had passed an order, my lord, that because the Honorable High Court did not interfere with that, so, my lord, there is really nothing in our application. But that, in my humble understanding of the order, subject to my lord's interpretation, of course, would possibly not be the correct interpretation, because this honorable court, while dismissing my 711 case, had given us the liberty to apply for undoing other orders. So 711 we lost, there is nothing we can do about it.
That order rejecting your recalling application.
No, the impugned order here before your lordship is the rejection of my recalling application, as well as the written statement was directed to be taken.
Applications were rejected.
Two applications were rejected.
Yes. Now,
May I,
yes.
before placing the impugned order, just show that the Honorable High Court's order, my lord, where
Yes.
this liberty was granted, kindly takes a look at, my lord, page 259.
This is of order 12 rule 6.
Now, 259, this order is assailing my 711 rejection. And also there was one other part to the order, which was the suit to be proceeded ex parte.
711 is 252.
This is order 12.
711 is 252, annexure F.
252, 711.
252. Yes, yes, madam.
And it's 252.
my lord.
Order 12 rule 6 is 259.
Coming there.
Begin.
So where is that liberty granted to you?
Order 12, Rule 6. Order
There's
2.
an revision, my lord.
And
I'm
kindly
assisting.
takes a look at 259, my lord.
Next, my lord, 259, my lord.
My lord, the relevant portion is page 261. This is the revision from Order 12, Rule 6 rejection. My lord, the paragraph under such circumstances. Has your lordship got it, my lord? Page 261. I do not find any illegality or material irregularity in the order impugned, and the application under Order 12, Rule 6 of the Code of Civil Procedure has been rightly rejected. It is also recorded that the petitioner has only challenged this portion of the order impugned by filing revisional application. The learned court below has further held that as the petitioner has failed to file a written statement since the institution of the suit, although the statutory period of limitation was over, the court had no other option but to proceed ex parte with the hearing of the suit against the petitioner. Admittedly, there is nothing on record to show that the petitioner ever approached the learned court below for taking off the suit from the ex parte board against the petitioner and to allow the petitioner to file written statement beyond the period of statutory period of 120 days, accompanied by an appropriate application showing cause as to why written statement should be accepted beyond the prescribed period. Under the such circumstances, this revisional application is dismissed without interfering with the order impugned. In case the petitioner takes steps in the learned court below by filing appropriate application, the same will be decided upon a contested hearing strictly in accordance with law and on the merits of the causes that may be shown by the petitioner. And the next page, 263, your lordship would find that is the order by which the written statement was taken on record and mullered along with the acceptance application. Now, two other applications we filed. Those are pages 56, page 56 of the compilation. That is a show cause petition, that is 256. I'm sorry, 56 of the compilation.
So after this order was passed, you filed a written statement along with a petition.
Along with the petition, that is one set of the filings. The two other applications we filed. One is at page 56 of the compilation. That is a petition for showing cause. Really explaining, what prevented us from filing the written statement, though as it falls from your lordship, it's really legally we cannot sustain, but that is what we were advised, by the erstwhile advocates,
Page 73 is the
And page 73 is the other application, which we filed for recalling of the ex parte order.
of the compilation. 70.
Now the causes shown are from paragraphs 10 to 13, at page 76.
Yes.
Now your lordship would kindly have a look at the impugned order, So, as on the date when the learned court below considered passed the impugned order, three applications were on board: a show cause petition.
What the defendant number 2?
Yes.
I'm the defendant number 2. Not a show cause petition, an acceptance of W.
Give me a minute. Let me go through things.
I'm sorry, I'm sorry.
Yes,
My lord, as your lordship would see from the, my lord, second paragraph of the order, the learned court below proceeds on the basis that the written statement was filed but without any application for accepting the same.
yes.
That, in my humble submission, is, my lord, contrary to the records.
No, which paragraph says that?
My lord, second paragraph of the impugned order, my lord, the paragraph starting with after transferring the instant suit, my lord. My lord, your lordship would see the last sentence. The sentence starting with thereafter by way of put up. Has your lordship got it, my lord? Thereafter, by way of put up on 28/2/2020, the defendant number 2 filed the written statement without filing any application for accepting the same. This, my lord, is contrary to the order which is recorded at page, my lord, 263 of the, my lord, transferor code. But that application was never considered. But in all these years, that application for acceptance of the written statement filed on 28 February 2020 was never considered. There is no order on that till date. Now, my lord, the suit gets transferred
Yes,
to, my lord, the commercial court.
yes,
And, my lord, we file two applications. One is for recalling of the ex parte order. The other is a petition for showing cause. These two applications were taken up for hearing together and was rejected, dismissed by way of the order impugned.
yes,
Now, your lordship would kindly see really what is the basis of that. Kindly takes a look at, my lord, page 22, the impugned order, my lord, the ordering portion after heard the both sides and considered materials on record, my lord, the paragraph which
yes, I've seen
it is found to me.
yes,
It is found to me that the learned transferor court had already curtailed the liberty of the defendant number 2 to file written statement by its order dated 17 December 2019, and by the order dated 6 February 2020, the Honorable Court had not interfered with the said order. Therefore, the order dated 17 December 2019 sustains now. Furthermore, as per subsection 3 of section 15 of the Commercial Codes Act, it is averred that provisions of this act shall be applicable to those procedures that were not complete at the time of transfer. It is appropriate to state, therefore, said provisions, then it is, my lord, quoted. Now, my lord, may I pause here for a moment with my lord's kind indulgence? My lord, the first ground is that, my lord, since that order by which it was directed to proceed ex parte was not interfered with the High Court, so that is why, my lord, it cannot be undone. But that, in my humble submission, is perhaps, my lord, an incorrect appreciation of that of the order passed by this Honorable Court, where, my lord, the Honorable Court was considering only the Order 12 Rule 6 application rejection, and, my lord, a specific liberty was granted that we shall be entitled to take out an application which would be decided in accordance with merits. That decision on merits never took place. My lord, so we had filed that application before the transferor court, 2 years prior to the date of transfer. So that is my first point, that possibly, my lord, the learned court below erred in, my lord, going on, misdirected itself, my lord, possibly, in my humble understanding, subject to my lord's consideration. Second point, your lordship would see the next paragraph. My lord, in the instant case, the learned transferor court by an order dated 17th December 2019 had already fixed the matter ex parte. On ex parte board against the defendant number 2, and the said was affirmed by the honorable court. My lord, there was no affirmation of that ex parte order. It was not even challenged. The only challenge was 12.6, my lord. So, my lord, this finding is also perhaps, my lord, is incorrect. Third is, my lord, your lordship would see that, my lord, the
Yes.
My lord,
my lord, third is your lordship would see, my lord, the next point is, my lord, that relying on SCG contracts,
Yes.
my lord, this order was passed, which is, my lord, that time to file written statement is 120 days, and it cannot be filed thereafter. My lord, that is applicable for commercial courts, where there's an amendment to Order A Tool 1, which says within 120 days it has to be filed, failing which the defendant shall forfeit its right to file written statement. My lord, that consequence, making the provision mandatory, was specifically incorporated only in case of commercial suits. Now, my lord, I am backed by 2 judgments on this point, that, my lord, in case of a transferred suit, these timelines are not applicable. And if your lordship kindly permits me to place these 2. Mr. Kundu, if you could please hand up to my lord the judgment of Shayan Sarkar by this honorable court. But a coordinate bench judgment, my lord, of this honorable court, my lord, dealing with a transferred suit and time to file written statement, and thereafter I shall place a Supreme Court on that. Lord, kindly takes the first paragraph. Your lordship would find it was a suit filed before a regular court, regular civil court, not a commercial suit. And in second paragraph, the date of filing is given.
Yes.
My lord, your lordship would kindly, my lord, have a look at, my lord, paragraph 2 on the next page, where, my lord, this judgment of SCG contracts was relied upon by the plaintiff, towards the middle of that page.
Yes.
Then, my lord, kindly takes a look at, my lord, the relevant portion, my lord, at, my lord, paragraph 8. My lord, this is, my lord, page 6 of the, my lord, the judgment, paragraph 8. It is a matter of record that the commercial court in Alipur was established and started operating on and from July 5, 2019. Even if dispute was a commercial dispute, the said suit could not have proceeded as a commercial suit, to which the rigors of the said act would be applicable in absence of a court in place. Then, my lord, so, my lord, ours is also commercial court Alipur, which your lordship would find the date of the setting up of that court. That is why I placed that paragraph. Now, kindly sees paragraph 9. In the order impugned, the learned court below had categorically recorded that July 5, 2019 was the date when the commercial court of Alipur started functioning for hearing commercial suits in the district of South 24 Parganas. So, my lord, that is the other finding. Now, paragraph 13, where this issue has been squarely dealt with, paragraph 13. Page 10 of the judgment, my lord. Therefore, in the case in hand, the mandatory provision of filing the written statement within 120 days from the receipt of summons in case of a commercial suit will not be applicable in case of a transferred suit like the present one. It is also a matter of record that the defendant filed the written statement on the date fixed by the learned civil judge. On 4 occasions, dates were fixed for acceptance of the written statement, but the business of the learned civil court did not permit passing of an order of acceptance of the written statement. Thus, the litigant cannot suffer for the inability of the court to hold the proceedings on those days. An act of court should not prejudice no one. Thereafter, the suit was transferred to the commercial. Then, my lord, two other portions, paragraph 18, where it says that, my lord, SCG contracts is not applicable for transferred suits. That is paragraph 18, my lord. My lord, two other portions I shall trouble your lordship with.
Yes,
Just above paragraph 20, the last 5 lines of paragraph 19, if my lord is pleased to take a look at.
yes,
The learned judge failed to exercise his discretion by taking into account the proviso to section 15(4). In any event, the mandatory provisions for filing the written statement within 120 days did not apply in this case at the time of its institution, and the learned court had the discretion to accept the written statement which was already on record. The order impugned is set aside and quashed. The learned commercial court is directed to accept the written statement. Now, the one other judgment, my lord, on the issue of, my lord, these timelines are not applicable for a transferred suit, my lord, is 2022 SCC Online SC 1877. Mr. Gundu, if you could please hand up a copy of that judgment to my lord. Raj process. But I am not troubling you, lordship, with the other facts, which shows that when the suit was filed before a civil court. If I may humbly, my lord, beseech your lordship to kindly, my lord, come straight away to paragraph 12, my lord, where the plaintiff had placed this SCG contracts, which is the basis for the order impugned.
yes,
Then paragraph 13, my lord, but we do not agree. The suit became the subject matter of dispute. No, the suit that became the subject matter of dispute in SCG Contracts India Private Limited appears to have been filed before the commercial court and not before the normal civil court. Insofar as the normal civil courts are concerned, it is the proviso to Order 8 Rule 1 CPC which applies. In Salem Advocate Bar Association versus Union of India, 2005-6 Supreme Court cases 344, this court held that the proviso to Rule 1 of Order 8 CPC is directory and not mandatory. An exception was carved out in SCG Contracts India Private Limited to this rule by this court insofar as the commercial disputes are concerned by invoking second proviso to sub rule 1 of rule 1 of order 5. Therefore, to apply the same principle to a matter where the suit was instituted before the normal civil court and transferred to a commercial court after the expiry of 120 days would be to give a complete twist to the interpretation given by the 3-member bench in Salem Advocate Bar Association to the proviso to order 8 rule 1. So, my lord, it really, my lord, falls back to, my lord, what the vested right was as on the date prior to the transfer. But here is a case where, my lord, the written statement was already filed, completely understandable, it's beyond time, my lord. But, my lord, the rigors of, my lord, the commercial courts and the amendments brought to the CPC by the Commercial Courts Act, my lord, cannot be made applicable for a transferred suit, where my written statement was already filed, but was pending acceptance.
Yes.
My lord, your lordship would see the remaining portions of the order. My lord, this is really the basis. That first is that order was not undone by the honorable court, and secondly, my lord, SCG contracts.
Yes.
So, my lord, in these facts, my lord, your lordship would kindly, my lord, consider, my lord, the order which is, my lord, really, my lord, harsh, and my lord, perhaps, my lord, your lordship would exercise your lordship's jurisdiction to, my lord, undo that, because, my lord, my right to file written statement is closed forever. But despite my written statement being on board, pending acceptance before the normal civil court.
Yes.
So, my lord, possibly, my lord, in these facts, my lord, this order should be, my lord.
Mr. Gupta, one thing, you address the court only on the acceptance of the written statement, not on vacating the ex parte. If the ex parte order is not vacated, where is the issue of filing the written statement?
We have filed that vacating of ex parte order also.
You have not made any submission on that. Maybe you have filed the application for vacating. How did the court went wrong on that? That you have not made submission.
Yes, my lord,
Unless-
if you yes, I understand.
that-
I need to deal with. I understand.
So the written statement does not arise.
My lord, your lordship would kindly take a look at my application once.
Yes.
Yes, my lord, your lordship would kindly take a look at the compilation, my lord. Kindly takes a look at page 73 of the
That's
complaint.
same ground as in the acceptance of the written statement.
That is really the ground, my lord, which is, my lord, that I was advised that you are contesting order 711 application and judgment upon admission. If nothing remains in the suit, no point in filing written statement.
So
But that was what the advice we got. But your
Mr.
lordship would kindly see that it is not a recalcitrant litigant who was waiting for his.
Ground, is it a ground for vacating the ex parte order?
But the ex parte order was passed for the only reason that written statement was not filed. It is not that we were not contesting despite receiving the summons. But there are two grounds on which it can go ex parte. A, I am not contesting despite summons, or B, I have not filed written statement.
Show me the order fixing the suit for ex parte hearing and show me that order.
Yes,
By
my lord. Kindly takes a look at the 17 December order, which is
page.
at page 256. My lord, at 258. When my order 12 rule application was rejected, by that order, it was directed to proceed ex parte.
Give me a minute.
258, your lordship.
Yes, anything more?
No, my lord, only thing, your lordship would see that on that date, kindly sees page 256, only that application of mine was under consideration. Today is fixed for passing order on the petition under order 12 rule 6 of the CPC filed by the defendant number 2. But on this day, and in the last paragraph, that is seen from records that written statement not filed.
Tag below the tag. Yes. Yes.
Lordship is at page 258.
258. Yes.
Wherein the application under order 12 rule 6 was dismissed. At the same breath, the court has said to transfer to fixed as ex parte. When they preferred a 227 from this order,
No, I'm asking you, is it permissible to fix a suit for ex parte hearing on that date?
on that date, I'll tell you why. The summons were served in December 2016.
What are the provisions for fixing a suit for ex parte?
Now, I'll tell you very quickly. the defendant, it fell from your lordship that when was the summons served? They entered appearance on 27th of January 2017. The defendant number 2 filed an application in 2017 itself to liberty to file written statement. That was allowed. Date was fixed to file written statement. This entire thing, and then they did not file written statement in 2017. Whatever pleadings are here on record is absolutely suppressed.
Non-filing of a written statement is a ground for fixing a suit for ex parte.
It's not ex parte, it's undefended.
That's the order.
It's undefended. It's undefended. You appear, you do not file, it is undefended.
That's a different
Yes.
thing. I may choose not to file a written statement.
And then
I may
contest it.
demolish it. Yes.
Yes, then
So can
contest it. Yes, I bow down to it.
So
Then
can it
contest
be fixed for ex parte hearing?
Can't be ex parte. Yes, it can be. I bow. It is uncontested. You can choose, not ready and contest. You have option. Cross-examination, other things are there.
I may choose that you have filed such a bad suit.
And I don't need
cannot
not.
file a written
I'll
statement.
demolish you on the plain case itself.
So you cannot
Can't be ex
direct a
parte.
suit.
Can't be ex parte. I bow down to your lordship. Now in 2017, when you are aware of the suit, prior to all this application, you file an application before the court.
That's a different thing altogether. Whether he will be allowed to file a written
Okay,
statement
yes,
or not.
on this,
So on
I cannot utter any more words.
Show me the reason that bereft of this, because the only reasoning is that since it's ex parte, not set aside, nothing. That's the impugned order.
Yes, when this order comes in 17th of December, this order was challenged in 227. In 220, Justice Shorka's order recorded that only the portion of Order 12 Rule 6 is challenged, but not the remaining portion. That is recorded. So the defendant did not challenge the portion by which the suit was transferred to ex parte. They accepted that portion of the order. But Justice Shampa Sharka's order recorded that they will be at liberty to approach before the court below with the 120 days not abstain. But the fact that in 2017 you have already exercised your right to file written statement and took an order from the court to file written statement, then you did not file written statement, was suppressed. The order is on record in 2017. Then thereafter you filed 711 or a 12 Rule 6. The argument today on lawyers' suggestion or lawyer's opinion, I have not filed written statement, is perhaps incorrect. Because application was made in 2017 itself. Today we are in 2025. Till date, I have the order copy with me, the order number 3 in the compilations must be there, man. The order number 3 in the compilation. The compilation, I just check the compilation once, man. I have the order number 3 ta ache. No, but I have the certificate. No, this is the order, man. I just copy down it.
Compilation, which page?
No, may not be, man. I have a certificate copy of the entire order sheet. Copy then.
Give me a photocopy.
Because
Commercial court.
oh, wait, আলাদা
Oh, এটা নিয়ে নিন, এই নিন।
এটা আলাদা চলে গেছে এটা পাল্টে দাও কপি দাও না একটা হ্যাঁ আমার কাছে আছে
ওইটা?
আমার কাছে আছে
Yes.
Now the order number 3, 27th of January 2017.
Yes.
Plenty files, postal receipt kept with record. Defendant number 2 appears by Vogalatnam and files praying time to file written statement. Defendant number 2 files a petition, order 7 Rule 11, read with copy served to 7th of March for SRAD upon defendant 1, 3 and 4. Then Muller. To date for WS by defendant number 2. On the next page. Now defendant number 7th of March. Defendant number 1 appears and filed written statement. So you filed an application. A court allowed this on the very second day of the suit, Muller, and then you kept silent. And then you went on saying the lawyer has said, don't file written statement. And now you bank on the order which fell from your lordship that not filed written statement cannot be an ex parte. I bow down to lordship. Now, Justice Shampa Sharka's order in my respectful submission, is not a liberty given to the
Page.
page 262. 261 is the main portion. I'll just read, Malan.
Yes.
So this order of 2017 is completely suppressed everywhere.
No, but here,
Now I'll come to 261.
yes.
Under such circumstances, I do not find any illegality or material irregularity in the impugned order, and the applicant order 12 rule 6 has been rightly rejected. It is also recorded that the petitioner has only challenged this portion of the order impugned by filing additional application. The learned court below further held that the petition has failed to file written statement since institution of the suit. Although the statutory period limitation is over, the court had no option but to proceed ex parte with the hearing of the suit against the petitioner. Admittedly, there is nothing on record to show that the petitioner has ever approached the court below for taking off the suit from the ex parte board. This portion is not challenged against the petitioner, and to allow the petitioner to file written statement beyond the statutory period of 120
What
days
is, according to you, merger?
has to be, because you have accepted this order.
Merger is when challenged, not challenged.
So,
The,
yes, if it is challenged.
Bench was
It's challenged. If it is challenged. If it is challenged, then the appeal court's order will.
Can the question of merger,
No. Now you accept that portion of the order. I say, without challenging that last 4 lines of the order, whatever, between the parties, you accept the order of 17th of December. You could have, there are 2 portions of the order. Is order 12 rule 6, and the balance portion is placing the matter as ex parte. Why ex parte was put? Because of the order 2017. From 2017 till date, you have not filed written statement. Yes, it should have been undefended. It is, the word is wrong. But the right to file written statement. Here we are on the right to file written statement. Today it is not.
so according to you, it could not have been fixed for ex parte, but he,
That is right to defend. Right to defend.
so but he cannot be allowed to file written
Why
statement.
not? I bow down to this.
Show me what the reasoning of the learned trial judge in the impugned order with regard to this.
Yes.
Why the learned trial judge rejected their prayer for extension after, because rightly, wrongly, they have filed an application for extension.
Yes, after Rajesh Shorka's observation,
They
whatever.
are fine.
Whatever.
So it has to be decided. Show me the consideration of the learned trial judge on that.
Yes. Now, here, Malad, it's recorded the first page. After the checkered elevation of the facts, defendant number 2 filed the captioned application. IA number 1 for condonation of delay in filing written statement and
So
acceptance.
admittedly, that was fine.
Now, no application was filed on the order in respect of the order of 2017. That extension of time when in 2017
No.
the order was passed.
When they filed the written statement, they have filed an application for extension.
Yes, that came
So
along.
there is no dispute
There is
with
no
regard
doubt
to this.
There is no.
So rightly or wrongly, what you have said that earlier they have paid for time granted, that may be the ground or in the defense.
But
Show me
that
the
is
court's
separate.
consideration, how the court
court's consideration.
rejected.
Yes,
Show me.
I must say the 2017 order is not specifically mentioned.
What's the reasoning? Show
Yes.
me the reasoning
Reason-
while rejecting.
The reasoning is mainly that the portion of the 17th December order, the portion by which the
Was not challenged
was not
or not interfered with by the High Court.
that could not have been because
That's
the
not true.
portion
That's
is not
that's the
Yes.
finding.
Right.
So only that,
Yes,
but
that-
not
that
on merit.
portion is not challenged.
but not on merits of the application for extension.
Not on merit on that petition. So it
Anything more?
proceeded. Yes.
Anything more?
Anything more? I say today 2 things which once to sum up, Malab. They have a right to defend, but without a written statement. But they cannot be allowed to file written statement today because 2017 order is there. They have not challenged in anywhere. All these 7-8 years have gone from there. Today in 2025, they want to file written statement. Now the commercials code, the timelines is not applicable. That I am not arguing on that. In the event, alternatively, in the event Lordship is not with me and is minding of granting them liberty to file written statement today, because written statement is on board. Now, yes, on that application, written statement was not taken on, it was kept with record. And a copy was not served. Now, she will kindly see that order.
No,
Yes.
copy of what not served?
Not this WS5 served করেছিল? No.
What?
Just Lordship. This application, Lordship will kindly see the order.
Application not served.
Defendant files application along with written statement, copy not served.
No, copy not served on that order. So do you mean to say when this application was taken up for hearing before the commercial court, till that time it was not served? You have not raised that point. You could have said, I have not been served.
No, no.
Interim order does
is
not
not
record that.
That is not because this team was not there in the court below. What is not on record, I cannot make a submission, man. Now today, if Malad is not with me and allowing for a written statement, Malad, should be put on terms. They put on terms. First is your right to defend the case without written statement. But then a bad case, different number two, you can cross-examine my witness and do whatever you feel. Now, if it is at all, the alternatively, whatever, it should be on terms. It cannot be on 27th. And the main case is lawyers have given opinion. Their entire responsibility is on lawyer. So everybody will come to court and say, I don't know the law because I am a litigant and a lawyer's responsibility. So, and this can't be. These are my
Yes,
And, Mr. Mitro, even they have not filed the application for acceptance of WS with the WS they had filed.
Deep knowledge.
No, that application file chilo.
what do you say that you have not challenged in the earlier round of litigation? You have only challenged the order portion of the order under Order 12 Rule 6, not the portion by which ex parte was not vacated.
But that is my CAN 2. That is my IA 2, which was dismissed.
High Court you did not challenge. By this, why you have
Because we filed a recalling application. We filed a recalling application. We did not challenge in High Court.
No. When did you file the recalling application? When did you file the High Court civil revision? Please give me those two dates.
Yes, in that order, the recalling was filed later, after the civil revision.
That is why I am saying. So when you have challenged, only the portion of the order under Order 12 Rule 6.
Only Order 12 Rule 6, and because the Honorable High Court.
Mr. Gupta, you have accepted that portion of the order.
No, because we have filed a recalling of that order. We have filed a recalling.
Mr. Gupta, that's subsequent. That's subsequent. When Justice Sarkar passed the order, you have not challenged that order.
No, we didn't. We only challenged the Order 12 Rule 6 dismissal.
Judicata, Mr. Gupta.
No, possibly, in my humble understanding, subject to my law testing it, of course, possibly, that will not be, because I have challenged it subsequently, which is the one of the applications which was dismissed by the order impugned.
Anything more?
I had filed the application for recalling.
Anything more?
The other thing, my learned senior friend was talking about suppression. That application for extension to file written statement is page 24. So we have not suppressed anything, Milord. That is annexed at page 24 of the revision.
Page 24.
24.
I'm not suppressing here, I'm suppressing before the other courts. This application was allowed.
So this we have annexed.
The application was allowed. Page 24.
And Milord, just for the completeness of that argument on which fell from your lordship the query, Milord, my application for recalling of that ex parte order is at page 73. Milord, the prayer is your lordship at page 77 of my compilation.
Page 24 is the application which of
Yes.
this.
And Milord, the recalling order
73 of your compilation.
of my compilation at Milord 77, your lordship would find the prayer where I have prayed for recalling of that ex parte order. So Milord, perhaps Milord, we have not really
Subsequent
that, right?
2 years, after 2 years.
Yes, I understand that is there, but we did not challenge that order and we filed the recalling.
Yes.
See, page 24 of civil division. That was the earlier 2017 application.
Yes, that is what my learned senior friend was saying we had suppressed. I am saying there's no suppression of that.
Page 2. Right.
I'm grateful.
Good.
Really? Really asked them. Judgment format. This application under Article 227 of the Constitution of India is at the instance of the second Yes,
Order to
the land
in the before the trial court, before the learned commercial court at Alipur, they had refused to file any affidavits to my application. Let them not come up today and say I want to file an affidavit in my, because they had said they don't want to file
For what?
to my IA 1 and 2.
Yes,
Both.
I'm giving them liberty. যেখানে
But my lord, they had specifically said they do not want to
Yes,
file.
you don't want to file.
They had specifically said they don't want to file. There's an order, my lord. I'm not carrying those, my lord, but let him say what he wants to, my lord.
There was nothing except for the records was there. Whatever the conduct is, it was required.
The
Lordship will
plaintiff
give us
opposite
liberty,
party
sir.
will be at liberty to file a written objection to the application for condonation of delay in filing the written statement within the time that may be fixed by the learned judge commercial.
The next day itself, we will go and file it.
So you do it within how much time?
1 week.
Your lordship
Acha,
fix the time accordingly. Will we?
All right. Within
Fine.
a week from the date of receipt of a server copy of this order.
My lord, a week may be granted for me to file a reply to their opposition, my lord. Lordship will direct here, my lord. We can go straight away and hear the application, my lord.
Affidavit in reply to the written to the affidavit in opposition. তাহলে ওটা না objection না করে what is being styled as affidavit in opposition
Affidavit in
there.
opposition,
তাহলে
yes.
affidavit in opposition বলে দিন আর reply thereto if any be filed by the petitioner herein within a week thereafter.
I'm grateful, my lord. Grateful.
Grateful, my lord. Deeply obliged.
Yes, coming after 5 days.
Coming up after
Item number 10. নয় আছে?
My lord, I was in item number 9, my lord.
Yes, Mr. Das.
My lord, this is a suit for matrimonial dispute, my lord, dissolution of marriage by the husband. I am for the wife.
Yes,
My petition for maintenance pending right, section 24, my lord.
yes.
My lord, although I have claimed before the learned judge in the court below that my husband is working as a manager in a nationalized bank and his salary per month is not less than 1,37,000. But despite that, in the impugned order, the onus of proving the salary of the husband has been put upon me. And in the affidavit of assets, since the husband, after deductions of his 4 EMIs worth 75,000 rupees per month, his net salary has been shown to be only 37,000. Therefore, the maintenance pendentity for me as well as my heart patient minor baby boy, my lord, it has been fixed at only 12,500 rupees per month. My lord, this is my grievance before my lord, my lord.
Mr. Das, where is the affidavit of assets filed by the husband?
Affidavit in assets filed by the husband, I have annexed, my lord. Kindly comes to page 37 of my my lord's brief. Page 37 clearly shows that EMI deductions is worth 47,000 rupees per month.
Where is the salary which have been said?
My lord, salary disclosed in the affidavit of assets is net salary after all deductions, and that has been shown to be only 37,000. Whereas I've shown to my lord that his EMI deductions per month is 47,000, my lord.
The gross salary has not been shown.
God salary has been suppressed, my lord. And I have come to gather from the other friends that he's a manager with Bank of India of grade 3, wherein the normal emoluments are 1,37,000 per month, my lord. He has suppressed his salary, actual gross salary he has suppressed. And the learned judge in the court below has put the onus upon me, the wife, to prove the income of the husband.
Last, please hear the order. There is substance in the order. There is substance in the submission of Mr. Das, learned advocate for the petitioner, that the husband may have suppressed the income, suppressed his salary income, as in the affidavit only the net salary after deduction of the EMI of 4 loans have been indicated. Mr. Petitioner is directed to serve a copy of this application by register speed post with acknowledgement due and file an affidavit of service on the next date. First up, list this matter under the heading motion in the monthly list of September 2025. Yes, call the next matter.
Item number 10.
Pass over next.
Item number 11.
11, yes.
Lordship, in this matter, I'm led by Mr. Menu Bose. He's stuck in traffic. Lordship, may kindly pass over this matter.
Pass over, yes. Next.
Item number 12.
My lord, item 12, I appear for the opposite party. My lord,
Yeah.
my
Led by Mr. Chairman.
Who is for? You are for the petitioner? No.
No, opposite party.
my lord, I appear for the opposite party. My lord, there is one difficulty, my lord, why I am pressing for the matter today. My lord, from every order, the opposite party, my lord, files some revision, keeps it pending, does not appear. My lord, there is also one other order passed by a coordinate bench that pendency of the revision will not affect the hearing of the suit.
Mr. Gupta, can that order be passed today?
No. What I am saying is, my lord,
Thank
let
you.
it retain its position, my lord, because The next date is 1st of August.
13 yes.
Milord, I'm told, Milord, there is a caveat lodged. And the caveat has been served.
What is the impugned order?
Rejection of Order 13 and Rule 7 application saying that, Milord, Commissioner cannot do the job.
What are the points?
I tell you, Lordship, Milord. This is a suit for declaration that, Milord, the plaintiff is the owner of the Shali land where he carries on agricultural activity. Milord, the land was, Milord, a factory purchased by me, Milord, in a winding up proceeding from, Milord, this honorable court.
Where is the
Milord,
points? Where are the points?
The application is at page 52.
Mr. Banerjee, can I take up this matter from Baripur court?
Today, Milord, the caveator is there.
Not for the caveator. Can I take up this matter? It's from Baripur court. Do
My
you have any difficulty?
No.
All right. Where are the points?
Milord, page 52 is the application. And the points are, Milord, at page 60. I just want to know, Milord, the nature and character of the land in present time. That is, Milord, all that I want. I say, Milord, there is, Milord, a residential complex which has come up.
No, page 60.
60 is the, Milord, points for commission.
No, what's the purpose for Order 13 and Rule 7, Mr. Banerjee?
Milord,
Why have you filed this application?
Milord, to inspect the land and to...
Who is in possession? Can it be done?
No. Milord,
Point
only
number
the
three.
nature. Only the nature. Only the nature.
So,
Nature in present time, nothing else. Milord, let me confine myself, Milord, restrict myself to that. 2, Milord, can be done.
where is your allegation that what is the dispute in the suit?
Milord, the plaint is at, Milord, page 24. Kindly come to the plaint.
Yes. It's a suit for declaration of title
Saying
and
that,
for permanent injunction.
correct. My Lord will kindly have a look at,
You are the defendant.
Milord, I am the defendant.
Yes.
Kindly, Milord, have a look at the pleadings in the plaint.
Yes.
Milord,
What's the character of the suit property?
they say Shali, I say, Milord, there is a residential complex.
But Mr. Banerjee, the character of the land will be evident from the revenue records.
No, it will not.
Why?
Because, Milord, he has, Milord, produced a document which says it is Shali.
Yes.
Fine. Milord, we have produced a document showing that, Milord, this is no more a Shali. Conversion has taken place.
So you have produced the document for conversion.
Yes.
So Mr. Banerjee,
Milord,
if it is so, where is the necessity of point number 2 also? Whether it's a Shali, agricultural, barren land,
Milord,
nothing.
Milord, a commissioner is, Milord, eyes and ears of the court. Milord, he will just go.
But yes, but for the purpose of elucidating any dispute in the suit.
Correct.
So it's a
Milord, he
suit,
says he is,
declaration of title and for permanent injunction. It's based only on documentary and oral evidence.
Milord,
No
he says he is,
local inspection.
he says he is carrying on agricultural activity on the suit.
Yes.
Milord, on the basis he wants, Milord, a perpetual injunction so that I do not disturb his alleged agricultural activities.
Yes.
I say there is no question of agricultural activity because the only crop, Milord, now there is a residential complex. Milord, has been sold to the purchasers. Milord, they are staying, Milord, in the flats.
So this can be proved, Mr. Banerjee, by way of the documents. According to you, it's not an agricultural land. You have a conversion certificate. According to you, construction has been made. You must be having some documents. And according to you, it has been transferred. You must be having those documents. So, Mr. Banerjee, when these points
But this
can
would
be
simplify
proved
the case.
by no,
This is not
that's not the purpose of local inspection.
But kindly see the purpose.
So that's not the purpose of local inspection.
Milord,
Purpose of local inspection is what cannot be proved either by way of oral or documentary
Milord,
evidence.
that is 26, order 26.
No, what 39 rule 7.
Milord, there is a difference between 39.7 and
Order 39 rule
26.
7, order 26 rule 9. There is a difference.
very
I
thin
am
line
aware
of
of that.
difference. Yes.
So you will be finding if it is can be proved by way of oral and documentary evidence. All these are documentary
But
evidence.
this question
He
of
is relying
proving,
upon some documents to show that it's an agricultural land. And you are saying no, it's been converted. It was prior agricultural, converted, and all these
but
can
this
be proved
question
by
of
way of.
proving, Milord, possibly subject to correction by your lordship would come had this been an application under order 26 rule 9 for collection of evidence and all. Because, Milord, section 75 of, Milord, the court, read with, Milord, order 26 rule 9 says that, Milord, I can, Milord, ask for investigation and all, which should automatically go into evidence because of order 26 rule 10. But, Milord, order 39 rule 7 is wider. And my lord,
Anything,
this is
anything, Mr. Banerjee,
we
can
see,
be
my lord,
seen.
the language. My lord has gone through this, my
So,
lord, that's really
also possession.
my lord, I am giving up the possession part of it.
Indirectly, you are trying to
No,
prove that.
no.
You are saying, yes,
Only
I am
nature.
I am in
My lord,
possession.
only nature.
All right, today it's a
Nature
difficult
in
day.
present time.
Today it's a difficult day. So I'm making it only not today.
And my lord, the reasons that have been shown, my lord, in the impugned order are, my lord, one of a kind.
Reasons can be supplemented, Mr. Banerjee.
In every matter, my lord, when I appear.
Reasons can be supplemented because only thing is that what's the ultimate conclusion? If the ultimate conclusion is
I mean, I
correct,
follow.
no
I
use
follow.
sending it back.
My lord, if
If
that
the ultimate conclusion, I find yes,
my
local
lord, my only endeavor would be, my lord, to satisfy my lord's conscience that, my lord, if a commissioner's report, a half-page report comes saying that this is the activity which is being going on, or this is the nature of the land, my lord, that will, my
After
lord.
all, you have to keep in mind, Mr. Banerjee, the scope of the suit.
Yes.
So it's a suit for declaration of title and permanent.
It's not, my lord, for declaration of title even.
What?
Well, kindly see the language in
What's
which
what's the suit for? What is the declaration?
perpetual injunction.
Not for declaration of title. Yes.
My lord, it says
Solwana-
Shabboste. Shabboste.
Yes.
Yes.
Declaration, then injunction. Upon declaration of
If
title.
my lord construe it in that way, yes.
Has to be because I've seen Solwana.
Solwana dabi Shabboste
Yes,
perpetual
so
injunction.
declaration, then injunction.
Couched in one prayer. Right. Right.
So these are all documentary evidence. It has been to be proved.
My lord, I'll come, my lord. On a better day, my lord, I'll try to satisfy the
Yes.
person. May I, my lord, put in this affidavit of service, my
Do
lord,
anything? Yes. Pass
only
over.
to justify my presence today. No.
You will have. Your advocate on record is here.
Is that true?
She is there to justify your presence. Yes, next.
Item number 14,
এটা আমাদের তো এটা caveat নেই তো এটা তো caveat আছে but there is a caveat lodged
14, what is the impugned order?
my lord, order 1 rule 8 my lord allowed.
Then it has to be hard. Yes, 15, who is appearing? Pass over next.
14.
item number 16,
Item number 16, I'm of the opposite party. You what
Pass
happened?
over. Next.
item number 17,
দেখে যান পরপর দেখে যান না থাকলে দেখে যান
item number 18,
But I'm paying for short password. Mr. Mukherjee is appearing.
pass over next.
item number 19, item number 20,
Item number 20, I beg to appear on the petitioner, my lord. My lord, this is an application for expeditious hearing of my OA application pending before the learned LRTT. My lord, the order passed in 2018 by the Barashad LRO. Thereafter, it has been
Can it
challenged
be done
before
by
the.
the single bench?
My lord,
Can this order be passed by the single bench?
no, only I am praying for expeditious hearing
Yes,
of my
I'm asking
OA.
you for that. Can it be done, sir? Against
Yes.
an order, against
La-
inaction?
No,
of a
not
tribunal?
inaction, nothing inaction.
Expeditious. That's
Expeditious.
inaction.
Expeditious, a 2015 appeal.
Yes,
Thereafter,
has to be before the division bench, cannot be before the single bench.
civil revisional application.
Sir, how can you move West Bengal Land Reforms and Tenancy Tribunal Act? Do you have that copy of the act? I think section, there is a bar, single bench taking out. দেখি West Bengal Land Reforms Act এর কিন্তু তার পেছনে আছে। West Bengal Land Reforms Act দিন।
But
it's only the division bench which can exercise jurisdiction. Single bench do not have jurisdiction, and we are filing these applications before the single bench. And you are also producing some orders passed
Yes, my
in
lord.
CO directing. But can it be done? Please see. Yes, I am correct. Section 8. দিন তো বইটা। Exclusion of jurisdiction of all courts except Supreme Court and the division bench. So it has been excluded by the statute.
Except where that the court exercises its jurisdiction under Article 226 and 227 of the Constitution by a division.
Yes.
Then
So 27 has to be by the division bench, not single bench.
227 in a division bench. Then, kindly.
Done. 227 in a division bench.
Then kindly make it go out of list. I will mention before the division bench, my lord.
But I think this classification is to be changed.
I will try to mention it before the division bench. Make it kindly go out of the list for the time being, and I will take appropriate steps, my lord.
Then you have to, I think, it has to be COLRT.
COLRT, yes.
Classified, so you have to amend that also.
So I will amend that. I will take necessary steps. Let for the time being, let it be go out of list, and thereafter I will come up with necessary changes and amendments, and
this is an application
will mention it before the
27 of the Constitution. Pass over next. 22. Pass over.
22.
You are appearing.
Of the petitioner, my learned friend is there. It is the matter of
caveat is there.
No.
No caveat. Yes.
Not within my knowledge.
Not within your knowledge. Let me see what the endorsement says.
Early disposal only, my lord.
Disposal.
Paragraph number 6 and 7 suit, ejectment suit, my lord. The
caveat, yes. Ejectment suit. What's the stage of the suit?
Stage of the suit has been decreed in favor of the plaintiff. Thereafter,
yes. Title appeal. You want the title appeal to
yes, my lord, my lord.
Who are you in the title appeal?
Title appeal, Howrah Court.
Who are you? Appellant, respondent?
Respondent.
Respondent. What's the suit for? What was the decree?
Suit for ejectment and first position. My lord, the suit is 1990 and appeal 2012. One after another application
under Pass over next.
24,
Pass over.
25,
Pass over.
26,
26, my lord, I have instruction to appear on behalf of the opposite party, my lord.
Pass over next.
27,
Pass over. Pass over.
I am for the opposite party, maybe not today.
Pass over.
30,
Pass over.
1.
I beg to the petitioner.
Yes.
My lord, one title suit was filed, my lord, by the opposite party, respondent, my lord, for declaration and permanent in declaration that he is a tenant in respect of one shop-room, and my lord, permanent injunction without.
What is the impugned order?
My lord, impugned order, my lord, Learned District Judge, my lord, has come into conclusion, my lord, which was not based on the.
There is a caveat, sir.
Oh, I'm sorry, I have not got. I have not got. My lord, I am serving it. And
Served or you have not served?
No, my lord, we have not got any copy of the caveat. So for my
It's
information,
an endorsement, sir. Please check up.
No, it's okay. When it is come from fallen from my lord.
Advocate, the learned advocate for the petitioner is directed to serve a
Item number 11.
Yes.
Same as, my lord, your lordship's judgment passed in Damayanti Devi, Khaitan Consultant versus Damayanti Devi. It's identical situation. I'll first give you lordship. I'll start with what is a complete handicap to me. Lordship, this is your lordship judgment.
The same order.
No, not same order. Another eviction suit application is the same. And their impugned order had some reasons. Here, it has nothing. This is the only difference.
Charges.
Same, identical application asking for occupation charges. That's what I said. But only the difference, I'll tell you, lordship. The first para, there would be some difference so far as the order number and the ejectment suit number is concerned. Now here the area in occupation is 1166 square foot, though your lordship has not mentioned.
Going into that, I'm saying this is the issue, this is the impugned and I'm following this.
Yes.
Ashun, no caveat is there, Mr.
No, there is none.
Caveat is not there.
For the petition on this matter, Lordship has heard this matter previously, wherein there's a the OPW has
caveat.
No caveat. There's no caveat. OPW has been closed. Your Lordship said come back. There's a lower court date was very near. That's why Lordship should adjourn it for some time. I will hear after the date is over. Now it's now fixed on 1st of September.
So I'm making it only not today because let the other side come.
There's no other side, Your Lordship. There's no caveat, nothing. No other side, nothing, Your Lordship.
No other side is there.
No other side.
Yes.
Yes, Your Lordship. Kindly come to the impugned order wherein the OPW has been closed of the insurance company herein. And Your Lordship, kindly come to the last page.
Yes, your opposite, your evidence has been closed, but
Yes.
you have not filed any application for recalling.
We have filed an application. Your
Where is
Lordship.
that?
Yes, Your Lordship. Kindly come to the application. Annexure A, Your Lordship.
Page
10.
What is the document?
Your
Which has
document.
come in your hand?
Yes, Your Lordship. The
You have not
document
specified that.
Yes, Your Lordship, we haven't specified, but we have categorically given submitted before the lower court.
What is the document?
The documents are, Your Lordship, we have done certain investigation on our end regarding the genuinity of the claim. Your Lordship, we have found that
Yes. Where is that document? You have
that has not been annexed.
then-
That, Your Lordship, my submission is give me a
you
list.
have to pay before that court.
For that is an opportunity to be given to us, Your Lordship.
Opportunity. You have not produced any document.
Yeah, we will, as if Your Lordship directs, we will produce and that the court will consider it. If it's not at all an admissible evidence, the court may reject it on first instance, Your Lordship. My humble submission.
What is the document? Do you have it here?
Yes, Your Lordship, I have.
Yes, show me.
Have the documents, Your Lordship. Your Lordship, this is the investigation report.
Yes, investigation done by whom?
My own private agency, but no, Your Lordship, we have derived from then we have sent it to the forensic also, and we have got hold of
Did
certain.
you lead evidence? No, you did not adduce any evidence.
No, nothing.
So you have to.
We have not got an opportunity.
So opportunity was there.
Opportunity was there. I missed the chance, Your Lord.
What
Your Lordship,
when you have not specified anything.
Your Lordship, then that opportunity at least to be given to me.
That you pay for there. This application under Article 227
Just
of the
Sorry, I did not appear at the time.
Yes.
Lordship, before I'm just coming to the Lordship, the impugned order. Lordship, initially I am the plaintiff.
What is the impugned order?
Lordship, Section 10 application has been allowed. Now, Lordship, before that,
What are the two suits?
the initial suit was filed by the defendant is a partition suit.
Initial suit filed by the defendant, partition suit.
Partition suit.
What is your suit?
Now, partition suit, there are so many defendants along particular several plot numbers. I filed a suit for eviction of the defendant, particular defendant who filed this Section 10 application. From this, a particular plot, which is the also subject matter of the partition suit. The total suit is, Lordship, cause of action is different, prayers also different. Now, Lordship, defendant file an application for Section 10, that Section 10 application is allowed. Now, Lordship, I relied upon some judgment that has not been considered also.
The eviction suit has been stayed.
Yes, eviction suit has been stayed as the Section 10 has been allowed.
169, Justice Banerjee judgment. Justice Banerjee bole gaya.
Yes. Where is that judgment?
Justice Banerjee.
Lordship, I'm sorry, Lordship, there is a marking. Lordship, in terms of this judgment, both the suit has to be repeated, plaint and written statement, both each together. But Lordship, here in this case, absolutely, Lordship, this is nothing. One is the partition, one is the, Lordship, the eviction.
No, this judgment was relied upon.
Lordship, I have relied upon the judgment. That is, Lordship, AR 1957, Calcutta 727.
Yes, give me that.
Yeah. AR 1957.
Where is your plaint in the eviction suit?
Lordship, kindly come the plaint at starts from page 11. You have 57, 57, 78. Yeah.
Where is 57 Calcutta?
Plus 57 Calcutta. I'm sorry, Lordship, all the judgments I could not.
No, this is not an eviction suit and the partition suit.
But Lordship, relating to Section 10.
There are judgments on eviction suit and partition suit, sir. Direct judgments on this issue. Direct judgments on this issue. Partition suit and eviction suit.
This is Lordship Justice, Honorable Justice Anil Kumar Sen, that is AIR 1985. That Lordship substantially has to be the same. Directly and substantially has to be the same. The issue between the two suits. That is the Honorable Justice relying upon the.
What are the two suits there? No. What are the two? Yes.
Relying upon the Honorable Justice Asutosh Mukherjee. এইটা তো yes. Yes.
The issue that arises for consideration then the stay is vacated, amounts to allowing the civil division application. If that's order of stay is stayed now, it amounts to what will be done? Allowing a civil division application.
So kindly the motion stage.
I've said motion.
Please see, my lord, in this matter, I filed the caveat, but they have not served the copy, my lord. Here is a copy, my lord, caveat. But at 24th of March, they have challenged the order, my lord. They have filed this application on 30th of June, my lord.
And you have filed the caveat on?
26th. Like, can you see the caveat? Kindly see the caveat, my lord.
No, it's no caveat has
No caveat, but I have filed one. There is a caveat, my lord. Didn't they like to caveat? 26th, I filed the caveat. 24th order, they have challenged. 26th, I filed a caveat. They have filed this application on 30th of
Yes. So 30th of June, 90 days expired. Your caveat has lapsed.
So, yes.
So, let the stands please inform them because today
Mr. Shivaji Das is appearing for the matter.
Mr.
Mr. Shivaji Das and Aniruddha Chatterjee appears.
Yes, inform them.
Yes, yes, I shall.
Because they are not here today.
Yes, yes. My lord, I shall.
Yes.
I'm grateful to you. My lord, may I return back the caveat?
কেভিয়েটটা পড়ে গেল নাকি দেখুন উড়ে গেল বোধহয় একটা কিছু নাকি না না কেভিয়েটটা নিচে পড়ে গেল বোধহয় দিয়েছে দেখুন
পড়ে গেছে বোধহয় নিচে রেখে দাও।
Item number 34.
Pass over next.
Item number 35.
Lord, I am for the petition.
Sir, I am for the respondent number 1 and 2.
1 and 2.
1 and
1.
You are the effective respondent.
Yes, sir.
Respondent number 1.
1 and 2.
Oh, they have come, Lord. In the earlier question, they have not. Lord, I am filing affidavit in service.
There was no caveat. Why did you serve?
Lord, since the rainy season start, it is a question of damage of the legal rooms.
Sir, there is no caveat. Without caveat, you
Yes,
have served.
I know, Lord.
Why have you served? You have served all.
Stop all.
Then others are not here. How can it be taken up?
Let the present
1 and 2.
Respondent number 1.
There are others.
Happened legally.
Through legal aid,
Through legal aid
appointed for
appointed.
respondent number 1.
One.
I am appearing also for respondent number 1 and 2.
1 and 2.
1 and
And
2.
you are for?
1 million.
And
Legal
3
aid
and
from-
4 are there. You have served all. Then what can be done? Not today.
Let their presence be recorded. Let
No,
their
no presence today. Yes, not today. What a conta. Evidence service ফেরত দিয়ে দিন আজকে। If you have not served, I could have taken up. When you have served,
And adverse order. In the earlier occasion also I am lucky.
yes, next.
Item number 36.
Later appearance will noted. Appearance.
Item number 36.
Actually, my lord,
Pass over, next.
Item number 37.
Pass over.
Number 38.
না হইলো না হইলো দেখা যাবে।
इसमें 3-4 के করে দিন একবার।
Item number 9.
ওদের তো কোনো স্ট্যাটাস নেই।
Caveat I have served already, madam. There is a caveat I have already served.
Not today, next.
Item number 40. Item number 41. Item number 42. Item number 43. Item number 44. Item number 45. Item number 46. Item number 47. Item number 48. Item number 49.
I beg to appear for the petitioner. I am paying only for not today.
Yes, why, what is this matter?
This is for expeditious disposal.
Then why are you paying for not today? Ashun, this application under Article
E.
Yes, pass over. Yes. Pass over matter. Which item? Any caveat is there? No. Which item? 6. Only 6? Only 6 টা ডাকুন। Yes. Yes.
Lord, suit for eviction.
Yes.
And Lord, the suit was filed, order 39 rule 1 and 2 application filed. The learned court below passed an order not to obstruct the ingress and egress of the plaintiff. And Lord, but the defendant are disturbing to the ingress and egress. Therefore, one police help application under section 151 was filed. Kindly, my lord, have a look into the order passed on 17th of February 2023. Order number 1, 17th of February, wherein the defendant and his men and agents are hereby restrained from disturbing.
Challenging an order of 2023 and 2025 after
No,
2
my lord,
years.
the next order is under challenge.
Yes, May 2023.
No, my lord, 11th of May 23.
Yes, after 2 years.
Yes, my lord, I explained it in at paragraph number 60.
What is your explanation for 2 years?
My son is not residing here, my lord. The old father is looking after the matter, my lord. And after
What is the stage of the injunction hearing?
Nothing, my lord.
I'm expediting the injunction hearing.
And my lord, kindly direct the police to.
Cannot be done. Ex parte, I have delivered a judgment last Friday. Ad interim injunction cannot be implemented in this way.
I leave it to your lordship.
I'm directing the injunction application to be disposed of because police help cannot be granted on an ad interim order because its order of injunction has been passed only on the basis of your statements and the documents. Other side has to be heard. This application under Article 220 matter.
Number 51.
Pass over.
Item number 52. Item number 53. Item number 54. Item number 55. Item number 56. Item number 57. Item number 58. Item number 59. 59. Item number 60.
For the petitioner. There is no caveat, my lord.
You are for the opposite party.
No, petitioner.
There is no caveat.
No caveat. His matter, your lordship, heard once.
I heard once.
Just before the date of reopening, it is my bad luck. The matter could not be proceeded finally, my lord. Your lordship.
Come at 2 p.m.
Yes, yes. My lord. I will come at 2 p.m. my lord. I take up this matter. There is some urgency, my lord.
Today morning, I have mentioned the matter without status. Attach the status for inclusion.
Yes, what status?
To be listed on 7th July, but not listed.
7 July list হয়নি দেখুন তো
27th May, your lordship passed order.
27 May I passed order.
My lord, adjourn the matter and directed to release the matter on 7th July.
7 July দেখে নিন ওটা অর্ডারটা তাহলে থাকেনি কেন? Where is the order? Show me that there was a direction.
Letter আমি দেখে নিয়েছি adjournment, simple adjournment.
Simple adjournment, there is no direction. If you have said there is a direction, show me the direction.
Direction attach করে দিচ্ছি, order attach করে
No, that was directed to appear on 7th of. Show me that order. Show me that order.
Milord, at the time of writing, may I permit to mention item number 1533 in the combined monthly list, Milord, at page 499. Milord, matter is very urgent. If your lordship fix
There is-
any date,
There is no caveat.
no caveat.
No caveat, come today. 1533.
1533.
1533 টা mark করে নিন আজকে।
My lord, item number 109. We'll take my lord
Tomorrow, Mr. Dalapati. Mr.
I am not ready today, Milord.
Tomorrow is a difficult thing because
We have
this.
At your lordship's
Mr.
convenient time.
Mr. Dalapati, please see the list because I have fixed dates on the basis of the mentioning. I accept mentioning on Wednesday. If you can come today, I will take up. Tomorrow, because I have fixed dates up to August. I cannot take it up in that.
My lord.
If you come today, today is a.
Yes,
I can. You can make
ready.
yourself ready if you move today without caveat. I can take up. Because tomorrow, because you see the list. Tomorrow, I do not know how many.
On Friday. On Friday, any day, at your lordship.
Then you mention on Wednesday. I will fix
My
it.
lord.
Mentioning the urgency,
My lord,
I will consider
item,
that. because-
my lord, item number 109, my lord, very short matter. Will take my lord 2 minutes. Kindly, my lord, takes it up today, my lord. No caveat. I am for the
109.
109.
109 টা mark করে রাখুন তো 2 p.m. There is no caveat.
No caveat.
109 টা mark করে রাখুন।
My lord, item number 90 is for expeditious disposal.
109.
109. Gidisham only can
Item number
others.
90.
90. Only 90 এটা mark করে রাখুন। এগুলো ফাইলগুলো mark করে রাখুন।
My lord, item number 327 for restoration of motion matter. My lord, no caveat is there.
Item number
327.
have you served notice?
No, my lord, it is a motion matter.
Motion
my lord.
stage.
Motion stage, my lord.
327 টা mark করে রাখুন।
My lord,
327 you are ready with the main matter?
Yes, yes, we are ready.
with the main matter?
Ready with the main matter, my lord.
Because restoration is not a matter of.
No, my lord, ready with the main matter, my lord.
Don't say I am only ready with the.
No, no, my lord, we are ready with the motion stage. It will be helpful to us, my lord. The lordship takes directly, my lord, motion.
my lord,
আচ্ছা 327 টা mark করে রাখুন। 327.
my lord, 109, I come back at 2 p.m., my lord.
Yes, 2 p.m. after Mr. Kali's matter.
My lord, much obliged.
109 or
109,
327?
327, 90.
90.
Order is there on that. Thank you.
তোর সময় তো কাছে কোম্পানি লিস্টটা একবার দেখে দিন, যেগুলো ফিক্সড আছে। হ্যাঁ,
Lordship taking up 315, my lord.
Item, monthly list, item number 484.
pass over.
Item number 564.
Pass over.
Item number 567.
Your Lordship, item number 567, I am for the opposite party. It has come up without any notice to us, Your Lordship. And he takes it up tomorrow, Your Lordship.
Not today, next.
Great, Your Lordship.
0.
Pass over.
Item number 64.
Over.
Item number 741.
All right, back to appeal.
Yes.
There is no caveat.
There's no caveat.
Okay. May it please your lords.
Yes.
My lord,
Yes, what is the impugned order?
if your lordship kindly, my lord, fixation of the occupational charges, enhancing the same from 101 rupees to 7,000 rupees per month, my lord. A semi-rural area is very small grocery shop, my lord. Your lordship kindly, the petitioner is a tenant in a small shop room. My lord, kindly sees, my lord, annexure C, page 29 first.
Mr. Banerjee, what is the stage of the appeal? I am expediting the appeal provided you pay.
My lord, 7,000 rupees, I will be out of the shop room, my lord. My lord, kindly sees,
Mr. Banerjee, can you get an accommodation, similar accommodation in the same locality?
No, my lord, kindly, my lord, there must be some reasoning, my lord.
Asking you, can you get,
No, 7,000 is not the, it can't be, my lord. 7,000 not near about that, my lord.
what would be the amount?
In the memory, in the memory, my lord, 100, my lord, it can be maximum, my lord, 1,000 rupees, maximum to maximum, my lord. Maximum, my lord.
Have you paid anything? Have you paid any amount?
But I'm regularly paying the statutory rent.
Rupees 100.
Current rent, my lord, I'm paying.
When the decree was passed.
But very recently, my lord, appeal.
No, what is the miscase for?
Well, miscase for execution, my lord. In the executing court has passed this order. But appeal is pending.
Appeal no stay.
In the appeal no stay, my lord. In the I have filed the application, it could not be heard. In the appeal, I also filed an application for stay. There is no order. It is a very cryptic order, my lord. Seize the impugned order first, my lord. Kindly seize. Not a single averment. Why there any reasoning, my lord? Any reasoning?
But the materials you have produced in support of your case of occupation.
My lord, they have not paid anything. My lord, I have filed the application for stay. They have filed objection. They have not paid for any enhancement or any occupational charges. I have annexed the objection.
When the decree was passed?
Pardon, my lord?
When the decree was passed?
Degree, my lord. If your lordship kindly sees.
So since you have not paid the
page, my lord, 2019, my lord. Title food number.
19.
In 19, my lord.
Mr. Banerjee, since you have not paid the occupation charges, stay stood vacated. So the execution is proceeding now.
No, executing court has passed this order. My lord, kindly seize the order first.
No, this order was passed in 2024.
My lord.
So what has happened to the execution now?
In this stage, it is there. My lord, appeal is also pending. Executing court is not. There is no. My lord, I am.
All right. So according to you, this decree was passed in
2019. I have filed the
2019.
19, my lord.
So from 2019 till this date, how many months?
My lord, kindly seize the my title appeal 17 of 2020, my lord. Annexure page 38, my lord.
No, this decree was passed on December 2019.
2019, my lord. Immediately appeal was filed. I filed an application for stay. it could not be heard. If your lordship kindly directs the learned appellate court below to hear out the stay
So
application.
67 months from the date of the decree till now. So deposit at the rate of 2,000.
My lord, kindly, my lord, I will.
Mr. Banerjee was saying 1,000 is the
Sir,
option. I'm
maximum to maximum,
accepting that.
my lord, I have.
Banerjee, I'm accepting that.
My lord,
Your
kindly-
rate.
My lord, kindly sees, my lord. My two,
That's,
my lord,
Mr. Banerjee, you have to
two sons,
deposit.
both are handicapped. I have suffered an
Mr.
cerebral.
Banerjee, that is neither here. nor
Kindly,
there.
my lord, maximum. I could have said, my lord, 500 rupees. My lord, maximum to maximum. My lord,
1,000.
1,000, my lord.
All right, 67 months. Deposit 67,000.
My
I will
lord,
allow you to serve. You have to deposit, Mr. Banerjee. I'm accepting your amount. Deposit, I will hear them. Then the final amount.
My lord, then my lord, some mercy may be given to me, my lord. Some installment, my lord, I have.
No installment.
I cannot pay right now, my
Mr.
lord.
Banerjee, 67,000 is due till date according to your rate. I'm not saying 7,000. 1,000, I'm accepting that. Deposit till date 67,000 is due according to your own saying. Deposit that amount. I will direct you to serve. I will decide that.
That
I will
will be,
fix
my
the
lord,
amount.
I will have to vacate the, my lord. In that case, I will have to vacate.
Banerjee, your rate, you have to
Maximum,
pay.
my lord, that can
That's the law.
Yes, my
That's
lord.
the law.
My lord,
67,000 you pay or let it proceed accordingly. That you have to pay. Because I am accepting your rate. 67,000. Deposit. Show some bona fide by paying in. 100 is nothing.
But
Mr.
kindly,
Banerjee.
and on two installment, my lord.
No, two installment.
On two installment, my lord, I may
installment?
can pursue my.
All right, two installment, 15 days, as many installments you can.
Pardon, my lord.
Within 15 days, as many installments you want. 2, 3, 4, but 15 days you have to deposit the entire amount. As many installments, even 15, but you have to deposit that amount. I am accepting your rate, Mr. Banerjee. From 7,000, I have come to 1,000. I have accepted your rate. That you have to deposit from that's the law. From the date of the decree, if you want stay, you have to deposit that. I am not asking you to deposit at 7,000. That is now the law, Mr. Banerjee. It can't be helped.
But kindly sees, my lord. There is no assessment. It can.
All right, Mr. Banerjee, I am accepting your rate. I am accepting everything. According to your rate, I will decide that what would be the amount subsequently. And this amount will be adjusted with the final amount. Even if I come to a finding that it will be less than that, this will be adjusted.
My lord, 15,000 at 4 installment, my lord.
No. Not 15,000. According to your own showing, even 15,000 does not come to 500 rupees also.
15,000 4 installment, my lord. It is 67,000
No.
come, my lord.
And no stay till you deposit the entire amount, 67,000. 2 weeks, yes, I will grant you. 2 weeks unconditional, provided you pay, it will continue. I will direct you to serve. I will hear both of you and I will fix the occupation charges. And this amount will be adjusted with the final amount.
Weeks 67,000, my lord.
It's due as on this date. That risk you have taken. That risk you have taken. Otherwise, no stay, let it proceed as it is. Nothing has happened till this date. So it will proceed in its own way without stay. And let them take, you succeed in the appeal, 144 is there. You can pray for restoration.
I will deposit the sum with the learned trial court.
No. Pay. That's the law. Pay to them. Why to the learned trial judge? That's not the law.
That is the law laid down by the Supreme Court, my lord.
What?
Honorable Supreme Court, that it has.
After says payment.
No, my lord. The latest. If your lordship kindly.
Then I will apply. Mr.
2009, my lord. 2009, my lord.
Mr. Banerjee, then
I will
apply the rate of stay of a money order. deposit entirety. I will do that.
But kindly see Sumer Corporation, my lord, if your lordship kindly sees.
Yes. Then not that at that rate. Then I will.
Page 16, your lordship kindly sees.
Yes.
Paragraph, para 16, my lord. The current rent, my lord.
Where is the subsequent supermax?
My lord.
Yes.
Is paragraph 77, 78, and 79, my lord.
Yes.
Last three paragraphs.
Yes.
77, 78, and 79. It is to say the amount subject to payment is exceptional, and not to fix. Any excessive, fanciful, and punitive amount. But stamp duty ready reckoner. And third one is, my lord, should not be directed to be paid to the landlord direct during the pendency of the appeal or revision. Paragraph 79, my lord, kindly sees. Paragraph 79, your lordship kindly sees, my lord. Supermax. 77, 78, and 79. Ordinarily should but the amount fixed by the court over and above the contractual margin ordinarily should not be directed to be paid to the landlord during the pendency of the application. The deposited amount along with the accrued interest should only be paid after the final disposal either side depending upon the result of the case. Page 29, if your lordship sees once, my lord, and I have annexed the a grocery and stationery small within bracket. It is my trade license, my lord. The municipality of Memari municipality had issued me this trade license. It is a small, they have said.
Oh, Mr. Banerjee, this decision in Sumer Corporation, so it was a remand made, but the amount which the High Court has directed, that was directed to be deposited. That was directed to be. So you deposit at the rate of 7,000. I will direct.
No, my lord.
So that's the law. Mr. Banerjee, you are relying on this.
No, my lord. No, my lord. It has relied. The Sumer Corporation has relied on
paragraph 20.
It has the Supermax has been relied on, my lord.
Yes, yes. Then Sumer paragraph, you are relying on this paragraph 20. Deposit that. I will remand this matter. I will direct the learned executive court to decide that. But you deposit. I will allow you to deposit.
But my lord, kindly hear them, my lord. Kindly there, my lord, kindly seize the.
Mr. Banerjee, you are relying upon this judgment.
No, my lord, I am relying on
that.
My lord, I am relying on Supermax.
I was not aware of this. I went to the website. I have accepted it. Yes, you cannot get.
I am relying on Supermax. My lord, 3 judges bench, my lord.
Yes, yes.
3 judges bench, my lord.
Yes.
Supermax.
Yes. But Supermax has been relied upon in Sumer.
No, my lord, it is
consider that this is the judgment.
My lord, my
Mr.
lord.
Banerjee, once you have,
my lord,
when you have
I will be
cited,
outside from the my lord.
Mr. Banerjee, two things. 1,000 you pay it to them. If you want it to deposit, then it will be 7,000. That's the decision.
If I succeed in the appeal, my lord,
you will get return of that amount from the court, but deposit for the present. That's Sumer Corporation.
But may I come back, my lord, after taking instruction from him? If it is at all possible, he has suffered.
Possible you may not
suffered cerebral attack, my lord. But I will just have my lord come on the next week or any day convenient to your lordship, my lord. I will.
Then it will get back to its original position. You can take instructions and then come. Ashun, after some
769.
But shall I mention the matter for?
Yes, after that you mention. After taking instructions, you can mention. But provided you take instructions.
1,000, my lord, I will take instruction. But
Yes,
7,000
yes,
is not
next,
possible.
next,
Without taking instruction, I can say so.
769.
Without taking instruction, I
When
can
you pay that, I am directing you to pay, I am directing you to serve.
1,000 rupees.
Yes.
But, at least in 2 installment, my lord, kindly cease, but I will try to convince my client, my
When I
lord.
am directing to serve, provided you pay this 67,000. So I'm making it 70,000 consolidated within 2 weeks. There will be a stay for 2 weeks. Failing which, uh, Has to, because another month is going.
60 টা হবে না? Well, 60 your lordship was just hearing.
Yes, yes, please, these matters are fixed prior to that. Yes.
Item 769.
Well, I petitioner, my lord.
Yes.
There was a caveat and learned advocate,
Then
Mr. Snow.
caveat, Mr. Ghosh, I cannot take it up today. Pass over next.
Item number 886.
886, I appear for the petitioner.
Yes. Any
for-
caveat is there?
No caveat, no caveat, my lord.
Yes, yes.
Praying for expeditious disposal of a suit for eviction of 2010, in which my lord, the defendant entered appearance in 2010 itself, September. After 2 years, filed a 7.1 and 7.2 with a Section 5 application. So
7
that
is pending.
7.1, 7.2 pending with a Section 5. 2 years delay.
So I'm directing them to dispose of the 717.
Because 7.2 along with Section 5 pending for 13 years. And my lord, also one Order 1 Rule 10 which was rejected in 2013, court has again fixed that for hearing. It was disposed of my lord, on 6th of February 2013 at page 31. Kindly see my lord, page 31. Court is again fixing it for hearing. Page 31 is the rejection of Order 1 Rule 10. Kindly see my lord, last but one paragraph. Hence the application under Order 1 Rule 10 stands rejected. Page 31. Now last order, kindly see. Page 31, last 2 lines.
Yes. And that application has again been fixed for hearing.
Again been fixed for hearing. Kindly see order number 22, last order in the certified copy, 8 July 24. Fixing 12/9/24 for further hearing in connection with the application under 7172 and under Section 5 and under Order 1 Rule 10 too.
No, where is order 1 Rule 10 is not there.
Kindly see my lord, order number 22, my lord, last order.
Yes, order number 22.
Kindly see last paragraph.
No, Section 7.1 and 7.2, not order 1 Rule 10.
Your lordship is looking at not 8/7/24. Order dated 8th July.
Is 5th of September 2013. You said order number 22.
My lord, order number 22, Order 1 Rule 10 is my lord rejected at page 31.
Yes.
Now kindly comes to my lord the order number 22, certified copy at the back.
Yes, order number 22 is order dated 5th of September 2013.
No, my lord, lordship kindly takes my lord the certified copy at the last order, my lord.
Yes, certified copy, last order. I'm looking at that. You is adjourn the case to such and such, Section 7.1 and 7.2 along with Section 5. Order 1 Rule 10 has not been fixed.
No, after that, my lord, the last certified copy is not 8 July. It has been fixed. 8 July 24.
Oh. So how can it be, Mr. Banerjee? Because order number 22 is dated 5th of September 2013. How this also can be 5th of order number 22, 8th of July 2024?
The numbering is possibly incorrect, my lord. Because page 31 shows, my lord, that it is, my lord, order number.
No other application under order 1 Rule 10 has been filed?
No application. No other application.
That I will give you leave to impress upon the learned trial because I do not know what happened.
Lordship will kindly record my submission, my lord, that the Order 1 Rule 10 has been disposed of.
This
And my lord, the court, my lord, if the court is lying vacant, my lord, I am told he is under order of transfer. If it is lying vacant, then my lord, let the district judge, my lord, assign to some court. Kindly see 2010 suit, my lord.
Mr. Banerjee, I will give you liberty to approach the learned district judge for transfer.
For transfer. Kindly give me that liberty, my lord. Kindly see 13 years, my lord. 7172 with a Section 5. It is not maintainable, my lord. Section
Application under Article 27 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned Civil Judge Senior Division 2nd Court at Balasat to dispose of title suit number 110 of 2010 expeditiously. First, Mr. Banerjee, learned advocate appearing for the petitioner, submits that an application under Order 1 Rule 10 within bracket 2 of the Code of Civil Procedure stood rejected on
6th February 2013. Page 31.
On 6th of February 2013, but by the order dated 8th of July 2024, such application has again been fixed for hearing. First up, he further submits that the application under section 7 within bracket 1, comma section 7 within bracket 2 of the West Bengal Premises Tenancy Act, along with an application under section 5 of the Limitation Act, praying for condonation of delay in filing the aforesaid applications, have been is pending for a long time. First up, Mr. Banerjee further submits that the learned trial judge is under an order of transfer, and therefore the suit may be transferred to any other court. First up, in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite party. First up, however, the learned advocate on record of the petition shall be obliged to forward a copy of this application along with this order upon the opposite party or upon the learned advocate representing the opposite party before the learned trial judge. First up, from the order dated 6th of February 2013, it appears to this court that the application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure has been rejected. First up, in view thereof, it will be open to the petitioner to draw the attention of the learned trial judge to the fact that the application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure has been rejected, and the same is not, and the same cannot be said to be pending. First up, paragraph taking in the light of the submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by giving liberty to the petitioner to approach the learned district judge, 24 Pogonas North at Barasat, if the petitioner is desirous of getting the suit transferred to any other court. First up, if such an approach is made, the learned district judge shall consider the same in accordance with law. With the above observations, CO number such and such.
So far as not the kindly give the time frame for the 7172 and the suit note, because
transfer, then it cannot be made, Mr. Banerjee. Transfer, because once
the transferee code, your lordship can direct the transferee code or the original code not to dispose of, because kindly see 7172 is section 5, it has to be rejected. Law is well settled. 13 years.
Since when it is pending?
2012, Miller. Since 2012.
Considering the application under section 7 within bracket 1 and 7 within bracket 2 of the West Bengal Premises Tenancy Act is pending from the year 2012. This court requests the learned trial judge or the transferee court, as the case may be, to make an endeavor to see that the same are disposed of as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Miller, kindly give a time frame, Miller.
Mr. Banerjee, once it is transferred, timeline cannot be fixed now.
Well, only 7172 is the section 5. It can be not. We are going on with not evidence on the section 5. Lordship knows it is not maintainable.
Not transferred from now, it is difficult. I've said expeditiously without granting any unnecessary adjournments. Because the timeline I could have if the court was there. Because whether transfer, no transfer, all these things are there. Yes, call the next one.
With the leave of my learned senior lordship has recorded the section 7172 only. Lordship will also kindly record the section 5 application. All three of them.
Along with.
Section 7172 along with section 5. Yes. Just call the next matter.
Item 938.
Pass over.
Item 1000.
You are appearing.
Expeditious hearing, Madam. My lord.
Yes.
Suit was filed in 2007. After 16 years, the appellant petitioner got a decree. Put the decree into executions. They are paper title appeal. No order has been passed by the appellate court staying the execution proceedings. But I filed an application for information slip showing that no order of stay has been passed by the appellate court. In spite of that, executing court says no, the order should be from the appellate court. There is no order. Nothing, no stay order, no occupation charge, appeal has been filed, kept pending.
This application under Article 227 of the Constitution of India is a
hearing.
No, no. Yes, next.
Item number 1034.
My lord, I appear on behalf of the petitioner, my lord.
Yes. Any caveat?
My lord, I have served notice, my lord. No caveat, my lord.
No caveat.
Caveat, I have
Then how
served.
could you serve?
I have served, my lord.
Then cannot be taken up today.
My lord, this is the affidavit of service.
Then it cannot be taken up. Dekhi, file kar di. You have served today, you have taken a resolution. If you had not served, there was no caveat, I could have taken up.
My lord, initially, my lord, the matter was taken up, my lord, on 20th of February. My lord, I directed, my lord, to serve.
See it, say that. Not today. Next.
My lord, may it retain its position.
Yes,
my lord.
next.
Number 1090.
My lord, item number 1090, I appear for the petitioner. No caveat has been lodged in this matter, lordship.
Caveat has been lodged.
No, my lord. No, my lord.
No
No
caveat.
caveat. No caveat.
1090.
My lord, may I place the matter, lordship?
Yes, what is the impugned order?
My lord, the impugned order has been passed by the West Bengal Cooperative Tribunal without any jurisdiction to act as an appellate court in respect of the order that has been challenged. May I just give a small gist of the fact? The opposite party number 1 bought a flat condominium from in our society. In 2015, he made 50,000 deposit, voluntary deposit towards the building development fund, and there is a letter to such effect. In 2016, after 1 year, he changed his mind and he said that it was taken without his consent and by forcing him. It was a donation and not a voluntary contribution. Thereafter, he made several representation before the registrar. He filed a writ petition. It was taken up and disposed of with the direction upon the registrar to consider the representation and pass a reasoned order. That reasoned order was challenged before the West Bengal Cooperative Society, although the Cooperative Society Tribunal could not have taken it up because it is a challenge to the reasoned order. The Act itself has laid down as to which orders can be challenged before the tribunal and no other orders can be challenged at all. Lordship will kindly take up page number 146 of my application.
Yes.
Yes, this is the reasoned order passed by the registrar in compliance of the order passed by this Honorable High Court in the writ petition. Lordship will kindly see the first paragraph, the instant writ petition by file by Shri Alok Singh, who is the opposite party herein, against the state for obtaining order directing the authorities to decide the issues contained in the representation dated such and such. And the next paragraph, upon all concerned, the Lordship, Honorable Justice Somapti Chatterjee was pleased to dispose of the matter by directing the undersigned, the registrar, being the respondent number 3, to take a decision in accordance with law in respect of the petitioner's representative dated such and such within 6 weeks from communication, and the same is to be given to the parties. Now, Lordship will kindly take up the last paragraph of this particular order at page 149. It was held by the registrar that the 50,000 given to him was not a donation. It was given voluntarily. And Lordship will kindly take up the last paragraph number 3. Petitioner is at liberty to take recourse to section 102 of the West Bengal Cooperative Societies Act. Now, Lordship, 102, I'm sorry I'm not present there physically to assist my lord. 102 states that if there is any dispute between the members of a cooperative society, the complaint has to be lodged with the registrar. It has to be referred to the arbitrator under 103. Board of Arbitrator will pass an award under section 103, and only that can be challenged before the tribunal. This was simply a reasoned order of representation passed, and no appeal lies against it as per the Act itself. The Schedule 3 of the Act states exactly which orders can be challenged before the appeal. So in my humble submission, my lord, the tribunal could not have sat in appeal and decided that this representation has to be set aside and 50,000 rupees has to be paid back to the paid back by the society to the member.
Did you raise the issue of jurisdiction before the tribunal?
No, my lord, at that point of time it was not raised.
Why have you not challenged that?
My lord,
challenge that.
My lord, the jurisdiction point subject to correction by my lord can be taken up at any proceeding, my lord. It is inherent lack of jurisdiction. It is non-est, void ab initio, my lord. And now I am being pressurized to pay 50,000 rupees.
Yes, you deposit that amount, I will allow you to serve.
My lord, this is a without any jurisdiction, lordship, it has been passed.
That amount, you succeed, you will get back the amount. Deposit that amount, 50,000. You are a society, you can deposit 50,000. To
My lord,
dep-
society possibly have taken instructions, will not be able to, lordship. That is the only difficulty. But lordship, since since this is without jurisdiction, my lord.
Much cost the society incurred for filing this civil eviction?
My lord, they have appointed me, my lord.
Yes, yes. Yes.
My
Why
lord,
not raise this issue?
my lord, point of jurisdiction subject to correction by my lord can be raised at any point.
Bring the act. Yes, call the next matter.
My lord, taken up tomorrow, maybe tomorrow.
Yes, let me see. Yes, next. Call the next matter.
Item number 1103,
Pass over next.
item number 1140,
Pass over.
item number 1141,
Pass over.
item number 1188,
Pass over.
item number 1203.
And I'm for the opposite party. A third time they've obtained a interim order.
Today it cannot be done anything. Pass over next.
Item number 1278,
Pass over.
item number 1290,
Pass over.
item number 1294,
Pass over.
item number 1302,
Pass over.
item number 1344,
1320 আছে তো। Pass over.
item number 1344,
Pass over.
item number 1374,
Pass over.
item number 1407.
I'm for the petitioner.
Any caveat, Mr. Bhagat?
Caveat, there is no caveat, but it was hard. It is for the second time. They have been served. That is the difficulty.
Be taken up today.
Then tomorrow, my lord, I am praying for that purpose that water is seeping through the roof. The landlord make hole and my shop is inundated with water due to rainy season.
But in the absence,
And that's why.
how can it be taken up?
Kindly see the impugned order, that is order 67. First page of the certified copy. Dated 20th February 2024.
20th of February 2024.
Yes. Though inspection commissioner has given report, submitted report that there is abnormal hole on the
20th of February. No, 17th of May. Thereafter is 20th of February. Yes, you are appearing. Yes.
For the opposite party, we had 1407, 1408,
all
1409.
yes, yes.
up to 10.
Yes.
The
Yes.
what happened that pursuant to the previous proceeding,
So what is this order for? Local inspection?
inspection held, commissioner submitted report, and in the report it is submitted that the repairing is required. In spite of that, the learned court below fixed this matter for PH instead of hearing out the application.
Hearing application?
Yes. This is the.
Give me a minute.
বলে দেবো না এখানে হচ্ছে ওই ইমপিউন্ড অর্ডার পেজ 67 ওই 1320 ফার্স্ট ম্যাটার ফার্স্ট 20 ওই জিরোটা না না এই যে
Where is the report? Show me
that is the next page. Next page is the report, commission report.
Yes.
I beg to report that I have been appointed commissioner in the above notice suit for
holding commission work of local inspection of the suit property, namely Kormokar Jewelry and Sons, shop of holding number such and such, ward number 16, English Bazaar, municipality within PS English Bazaar, Post District Malda. Being appointed commissioner, I received writ and pleading papers from the court. After receiving writ and pleading papers, I have gone through the pleading papers and on 5/6/2023 served notice upon the parties through the learned advocate of the parties fixing 18/6/2023 as the date for holding commission work. On 18/6/2023.
Where is your application for repairing?
Yes. Huh?
15/6/2020.
No, page.
Yes, Malar. I'm supplying the page number.
So that is kept pending.
Yes.
Where is that application?
Possibly on page 20.
Page 20.
Possibly
20.
Yes, 20 probably. 20. Yes, 20.
May I just cut short the matter? Lord, so far I understand, Lord.
No. Yes, my lord.
The schedule of repair is at page 21.
Yes.
Lord, repair of the roof. Lord, so far I understand
electric connection repairing, shutter
the
repairing.
prayer is that the matter be disposed of by the learned trial court. Lord, I have to admit that the roof has come down. It requires immediate attention. There is no doubt about it. Now, my lord, so far as whether it is repairable or not, that is a question which has to be addressed. Now,
directing this repairing application to be decided.
Or my lord, what happened? The learned code below is not taking any.
Let them decide. Let the learned trial court decide, because the commissioner report is also there before the learned trial.
I'm directing the repairing application
No,
to be disposed.
before that, kindly consider the order passed in the previous proceeding by Honorable Justice Subhasis Dasgupta.
Yes.
He opined that after considering this commissioner's report,
Yes.
that is at page 18 probably. No, my lord, order starts from page 15.
Yes, so it is to be decided afresh.
Yes.
So that has not been done.
Not done.
So I'm directing the repairing application to be decided in the light of this.
Whether further consideration is required by learned trial court, your lordship can pass it. Because considering the report itself,
Commission report
was the direction.
That's right.
I have substantial.
That was not there. I could have.
Then there may be time limit.
Yes.
That I will shortest time.
Shortest time.
Because
What is the next date, please?
It is 25th September. That is long date.
Mr. Bhokot,
considering the rainy season, that shop is inundated with water.
I appreciate that.
They are not in a.
Mr.
They are.
I appreciate that, but
they are not in a position to open the shop.
I appreciate everything, but I cannot from here prepone.
Want to prepone?
Prepone cannot, because I do not know Mr. Bhokot, the
there.
diary of the learned trial. I will give you liberty to apply for preponing.
Yes. We shall file put up petition. We shall file put up petition
Yes.
for preponing the date.
Yes,
That
I will give you liberty for that, because from here, Mr. Bhokot, I do not know the diary of the learned trial judge.
That's
difficult to fix a date from here.
He is keeping this application for 3 years, pending for 3 years.
That I am directing. What is the date? Next date fixed you have said?
25th September 2025.
But kindly also observe that objection, if any in the meantime, may be allowed.
But objection,
He had not filed any written objection.
No. They have accepted it. They have not filed any objection to the commissioner's report.
No. He says that for repairing application.
That was considered.
Commission application objection was filed, which traveled to this honorable court. Thereafter, it was
They did not file any
objection.
No, for further.
They did not file any objection to the commissioner's report.
Only that was remanded to be considered afresh, because at that point of time the commissioner's report was not there. So now the commissioner's report has come.
Then your lordship will kindly look at the commissioner report once. Lord, the direction was that the commission be done by a local assessment commissioner. It was done by an advocate. Lord, that was also 3 years before.
They did not object to it. They admitted it.
Now the roof has entirely come down. The condition of the walls are not given. Are not provided. for the petitioner.
Yes. Any caveat, Mr. Haldar?
No, pursuant to the order passed by this honorable court,
Just stop. Then I
for
cannot
the
take up. Then how can it be taken up, Mr. Haldar? In their absence, we have taken a resolution.
120, my lord. I expected, my lord, the total list will be collapsed. But 120 of the supplementary list.
You expected
The list,
the list will collapse. It has not collapsed as yet.
my lord, 120 of the.
What is your impression? It has not collapsed.
I was not present. I was informed that, my lord, in the first time, my lord, those matters who are very urgent, my lord, your lordship has, my lord, fixed it at after the fixed matter. But I was not here, my lord. Is 120 of today's list.
120.
120 of today's list.
120
After
mark
this-
করে রাখুন, বাদ করুন।
My lord.
দেখুন কল করুন এবার পর পর। Yes.
31 কেউ নেই না?
কেউ আছে? Yes.
I'm in 3115, my lord.
No, what? You are appearing, Mr. Banerjee.
Yes, 3115, my lord. 315, my lord. I am appearing, my lord.
315.
Yes, my lord. 2 p.m. fixed, my lord.
Oh, daily list.
Yes, my lord.
Daily list 315 দেখি। But you are for the petitioner any
Yeah, no
case?
caveat, no caveat, my lord. There is no caveat.
আচ্ছা 315 টা রাখুন। Yes.
So this is my lord, application filed by us against my lord an order passed by DRT 3, wherein the initiation of the proceeding under 13(2) itself is my lord without jurisdiction. We have filed an essay.
That's an applicable order before the DRAT.
So this is not my there is a jurisdictional error. That is exactly what I am saying. My lord, my junior was there. Lordship has said there is a jurisdictional error. Otherwise, I would have gone. The initiation itself, there is no proceeding which can be filed, my lord, under the, my lord, DRT Act itself.
My lord,
That's exactly what I want to show.
for HDFC Bank.
You have instructions.
Yes, my lord.
What do you want?
But I want the matter maybe adjourned today because
Mr. Banerjee, the HDFC Bank has appeared. Have you,
I
have got
copy has been served. Mr. Banerjee, copy has been served. The opposite party is here. They are paying for adjournment.
My lord, I don't know, but my lord, only issue is that, my lord, against the order, they are proceeding to make.
Opposite party is here. She is paying.
Yes, yes. My lord, I am not standing in the way. I am only saying, my lord, they are proceeding to hold the, my lord, publication on first. Kindly, my lord, takes it up at tomorrow 2 p.m. My lord, I have no issue. Tomorrow at 2 p.m. Grateful, my lord.
You are appearing, no? Yes.
No, my lord. Tomorrow at 2 p.m. Grateful, my lord. Great.
আর কোনো ফিক্সড আছে ডেইলি লিস্টে?
Item number 327.
327. 77 fixed matter.
Fixed matter. My lord.
2 p.m.
My lord.
Yes. What is this?
My lord, I am for the petitioner, my lord.
Yes.
My lord, this is money suit, my lord. I am defended in the suit, my lord. My lord, the matter was taken up once by your lordship, my lord, and my lord was pleased to supply the subsequent orders, my lord. I have the certified copy of the subsequent orders, my lord.
Yes.
My
What
lord,
do you want
my
to challenge? What is the impugned order?
My lord, by impugned order, my lord, my application for vacating the ex parte order has been rejected, my lord. My lord will find the order impugned. That is,
yes, I directed you to produce the orders after 7th of January.
Yes, my lord. My lord, typed copy is also there, my lord.
21st of July. Today is date for
Yes, my lord.
So,
my lord, issue has not been framed yet, my lord. Suit is of 1999, my lord. Once, my lord, it was dismissed for default. Thereafter, again, someone was served, my lord. We appeared,
where
my
is the
lord.
impugned order?
My lord, it is, my lord, will find before, my lord, list synopsis, my lord, will find the
synopsis.
Yes, my lord. And certified copy is also there, my lord. It is at the last, my lord.
Which volume last?
My lord, it is before synopsis, my lord, will find the impugned order, my lord. 7 January 2025, my lord. My lord, all the orders have been annexed for that reason, my lord.
7 January 2025.
My lord. My lord, initially another application was filed, my lord, on technical ground that was dismissed.
By the order impugned. Photocopies of those.
My lord, I have supplied the copy of, my lord, the typed copy of the order, my lord.
Give the photocopy.
Photocopy I shall, my lord, I shall hand over.
ওটা দিয়ে দিন কিন্তু ওটা Yes. What is the next matter?
Item number 149,
Pass over next.
item number 60.
Yes.
But I am accepting the order passed by the Honorable Chairperson DRAT, whereby and whereunder, my lord, the Honorable Chairperson has been pleased to affirm the order passed by the learned presiding officer DRAT. I just briefly indicate the facts. My lord, the petitioner has borrowed certain amount from the opposite party bank.
What was under challenge before the DRT?
DRT, my lord, the petitioner has challenged the impugned order passed by the district magistrate.
Section 14.
Section 14. My lord, the subject matter of challenge was, my lord, that the petitioner made certain payments before the bank. And, my lord, the bank has filed an affidavit. Now, your lordship knows, my lord, under section 14(1), it mandates that the bank must disclose adhere to the 9 clauses. What are the 9 clauses? My lord, the 9 clauses, 14(1) says that the exact amount of dues, after taking into consideration, my lord, the amount.
Where is the order passed under section 14?
Yes. My lord, kindly see, my lord, the order, your lordship will find the order at page 62, the order of the district magistrate.
Possession taken.
My lord, the position has been taken, but the difficulty is this, my lord, the Honorable Chairperson, my lord, on the one hand saying that since, my lord, this matter has become infructuous, the appeal, now I cannot proceed with the merit, but he has passed, my lord, a elaborate order, my lord, dealing with all the points. It is a fit case for, my lord, remand. Because, my lord, what has happened, my lord, neither the presiding officer, my lord, has.
I am directing the SARFAESI application. I am expediting that. I am directing.
No, my lord, that will not serve my purpose.
Why?
Because, my lord, I tell you, lordship, why? Because I have filed a
SARFAESI application is pending.
SARFAESI application is, I have challenged the 13(2) and 13(4).
Yes. So I am
At the same
expediting
time,
that.
that
Sir,
will.
the possession has been taken
The
now.
position has been done, but your lordship kindly see test the veracity of that order. Because if the district magistrate has passed a wrong order on the basis of, my lord, the fraud vitiates everything. Well, if the bank has committed fraud, my lord, then has to be charged. Where shall I challenge, my lord?
if your lordship ultimately upholds the order of the district magistrate, then my lord, so far my possession part is concerned, that will be settled that possession.
All right, show me the order passed under section 14.
Yes, my lord. The order of the district magistrate that will appear, my lord, at page 99. My lord, annexure A. My lord, that is appended to the my put up application, page 99. Well, your lordship knows, my lord, under section 14, the district magistrate is bound to pass a reason and speaking order in terms of the, my lord, the in terms of the Supreme Court decision, my lord, in Nobel Kumar Standard Chartered Bank versus Nobel Kumar, it has clearly stated that the order should not be cryptic, it's a speaking and reasoned order. Although, my lord, it is fact that the district magistrate is just, my lord, rendering an administrative action, but at the same time, when the statute mandates that he is bound to, my lord, adhere to, my lord, section 14 subsection 1, disclose the extent of debt, but there is no such disclosure. I have made, my lord, I have made not only made, my lord, substantial payment, but at the same time, my lord, the petitioner is covered by the, my lord, the central government scheme where the central government is the guarantor. Is the Prime Minister, my lord, the rehabilitation fund. But the central government is giving guarantee, and for that they have already taken that amount from me. Without the bank has received more than 8 lakh, and without giving any adjustment to that, well, they say that the amount ought not to have been classified as NPA. This is my humble submission before your lordship.
Or I cannot consider that now.
I am not on
NPA, that is why I am saying
Yeah.
I am expediting the SARFAESI application.
Here I am, my lord, only for limited purpose. District magistrate order I am challenging. Because, my lord, if your lordship, my lord, remand the whole matter, late death matter will also be considered. Because neither the DRT, my lord, nor the DRAT has considered that aspect. DRAT on the one hand saying that your appeal has become infructuous, on the other hand, DRAT, my lord, proceed to deal with the merit. My lord, you cannot blow hot and cold at the same time. Well, if the DRAT and my whatever, my lord, notes of argument, my lord, I have produced before the honorable chairperson, but that has not been considered. With due respect, my lord, when, my lord, I have already indicated the factum of payment, my lord, there has been no endeavor to, my lord, record those. He says only that since, my lord, it is an administrative order, I cannot look into it. Well, that is not the law. When, my lord, I have challenged the veracity of that order, my lord, it is also, my lord, incumbent upon the presiding officer to look into it.
When have you paid the amount?
Yes, my lord. Kindly see, my lord, I have
the date.
Yes, I have filed a supplementary evidence. I have annexed all the
Give me the date.
Date, yes. Well, I have prepared a short list of dates to prevent it. Or may I just hand up a copy of the list of dates I have prepared for your lordship convenience?
Yes.
My lord, kindly come to, my lord, column number 5. My lord, reply made by the RTI and authority in reference to the request dated 22nd May 2005.
Have you got the copy of the affidavit filed by the bank?
Yes, yes.
Where is that?
Yes. That I have also annexed, my lord.
Page?
Yes, my lord. I am just giving your lordship. It starts from. My lord, it starts from page 101 to 103. That is the affidavit, my lord. Kindly see, my lord. And now, lordship sees the scheme of the
1 to 103.
Page 68, internal page, my lord. Page 68 is the internal page. Page 68, my lord. This is the affidavit they have disclosed. Well, since, my lord, I have got no right of audience before the district magistrate, I could not controvert this affidavit. So they have suppressed the entire factum of payment. My lord, kindly see section 14(1)(a) once. Can you just have this here?
When did you pay the last amount?
My lord, the last amount I have paid, my lord, total altogether 8 lakhs I have paid.
Yes. What is the last payment made?
Last payment I have made, my lord, that has been, yes. 28 June 2024. 23.
28th of June?
2023.
You have paid an amount on September 2023 also.
That pursuant to the order passed by the Lok Adalat. Well,
that also has been considered.
No, that has been considered, but that has not been considered. But the Lok Adalat says
been considered.
But the other
state of payment, it has been considered.
Not in the affidavit, my lord.
Yes, in the affidavit. Kindly come to page 70.
But prior thereto, the substantial payment has been made. That has not been said.
Sir, even this, you have said June, even the September payment has been taken into consideration.
1 lakh only considered. But prior thereto, my lord, I have made 8 lakhs. But there is no whisper.
Show me your application filed before the tribunal.
SARFAESI application.
Yes.
SARFAESI annex করেছো? But SARFAESI application.
No. The application challenging the section 14, the interim application. Section 14 you have challenged before the.
Why do I have a put up, my lord? Put
You
up
must have filed some
Yes,
application.
yes.
Where is that application?
Kindly come to page 104 to 107. That is the put up application. Yes, 4228 of 2024.
No, this 104, these are only some letters. Where is the application you have filed? Challenging the section 14.
I'm just
challenging the section 14.
Yes,
You
yes,
have to
section
have-
14. Yes.
Where is the order passed by the DRT? Show me that.
DRT, that order starts from page 62. Well, the put up application at page 90. Done it. Here, my lord, I have stated, your lordship kindly come to page, there are certain amendment I have made. Yes. I have also filed a supplementary affidavit annexing the factum of payment. Yes. Well, kindly come to page 95. I have stated 5 lakhs. Short. And paragraph 11, my lord, kindly see. 8 lakhs I have stated. Paragraph 11, page 95. But these facts have not been considered by neither the DRT nor the DRT. Only on the premise that it's an administrative order, my lord, they have washed their hands. But when a authority, my lord, is exercising a judicial mind, well, maybe quasi-judicial, but there has to be, my lord, some sort of, my lord, the application of mind.
Sir, you are not a necessary party at the section 14 stage.
I may not be a necessary party.
So, how can the district magistrate decide this point with regard to the dates?
But then, my lord, the bank should be more.
Please address me on
yes,
that.
Well,
It has to be on the basis of the affidavit.
Then,
so you challenge that.
But I have challenged, my lord.
So, sir, here the tribunal is only concerned with the propriety of the order passed under section 14. Section 14, you are not neither a necessary party. You are not before the district magistrate. So district magistrate has to consider only on the basis of
the statute
and the dates. If the statute says, show me that the statute requires that you have to be, sir, please hear me, thereafter show me the statute. Show me that the statute requires that you have to be heard.
First of all, I'm giving.
So what the DM will decide on this has to go by the epidemics
filed by you.
Yes.
See, if the bank chose to suppress all these things, then what would be the outcome, Malad? That means, Malad, then Malad, I will get, since Malad, I have got no right of audience, then Malad, only by Malad, a stroke of pen, Malad, despite of the fact, Malad, I have made substantial.
What is the amount due? According
only
to you
18
now?
lakhs, my lord. 18 lakhs. Only 18 lakhs.
Property has been sold.
Property has been sold, but I have challenged. Malad, that is also pending. But Malad,
Now what can be done? Now what can be done? So property has been sold. The purchaser have taken possession of that property. When the property,
I am asking for Malad, some protection.
what
Because,
protection?
Malad, in the meantime, Malad, status quo be Malad maintained. Malad, only this much. Malad, because otherwise.
No status quo now.
Malad,
Property has been sold.
property has.
So
But I am not asking for Malad restoration of possession immediately. But Malad, when a Malad, kindly give me 1 minute. Malad, when a borrower, Malad, he has made out a prima facie case, Malad, the amount ought not to have been
Serve them? No, not
I will
now.
serve, Malad, I will serve.
Yes,
But in the meantime, Malad, limited
No,
protection.
no stay now.
I will run after one after another, Malad. If they create a third party interest, Malad, I am not asking for restoration of possession.
It
But
has
I
been
am
sold. It has been sold.
let there be status quo.
Status quo without indicating the status. It's not.
No third party interest, Malad, only this much. Well, let them.
I do not know that. Yes, let them come. The
As listed motion, my lord.
Motion in the monthly list of September. Yes, call the next matter.
September, my lord, August, my lord.
Yes, yes, no.
My lord.
Yes, next.
Item number 90.
Grateful to you, Lord.
My lord, item number 90 for the petitioner.
Yes.
This application is for a prayer of expeditious disposal of title suit, being title suit number 126 of 2015.
What is the stage of the suit?
My lord, the next date is in August, according to my instructions. For hearing,
Injunction application is still pending.
my lord, injunction is pending.
This application under Article 227 of the Constitution.
Sumangi Bhattacharya is, my lord, appearing.
My lord, I appear on behalf of the plaintiff's petitioners. My lord, by the impugned order, a Section 7(3) application under the West Bengal Premises Tenancy Act was rejected on the ground that no ground of default of payment of rent was taken in the pleadings. However, my lord, Section 7 of the Act clearly states that this provision will apply if the suit for eviction is instituted by the landlord on any of the grounds mentioned in Section 6. So, my lord, this application has been wrongly rejected by the learned judge of the trial court.
Where is your application under Section 7(3)?
My lord, kindly come to page 11. Kindly come to page 25, Annexure C.
Page?
Page 25.
Where is your plaint?
My lord, the plaint has not been annexed.
What is the suit for?
Eviction.
Eviction on what ground?
Reasonable requirement.
Under the 1997 Act?
Yes, my lord.
Then why Section 7(1) was held to be not maintainable?
Because it was rejected as time barred.
Page number 21 is the order whereby the 7172 has been rejected.
Page 21.
Page 21.
Annexure B. Page 21.
by the order impugned, the application under section 7 within bracket 3 of the West Bengal Premises Tenancy Act stood rejected ground that in the plaint, the petitioner has not taken the ground of default. So the petitioner is directed to serve a copy of this application upon the opposite party by registered speed post with acknowledgement due and file an affidavit of service on the next date. To stop, there shall be an order of stay of all further proceedings in title suit number 110 of 2018 pending before the learned civil judge, junior division, third court at Ward 1 till the end of the month of November 2025 or until further orders, whichever is earlier. Contested application 12 weeks.
My lord, can short date might kindly be given.
Yes, call the next matter.
Grateful, my lord.
Number 120.
Your Lordship, item number 99. I am for the petitioner praying for note today. It has been
Item
called
number?
up. 99. It has been called up earlier.
What is it? 99 has not been called up. Yes.
No, called up. It has been called up.
99.
99. Sorry. Oh, 90.
120. Yes, Mr. Haldar.
Plaintiff decree holder is the petitioner before your lordship. Mala suit for recovery of possession on revocation of license. Suit is of 1987. That suit was decreed in 1999 and Mala that decree has
the
been
impugned order.
No, Mala, I'm coming, my lord. That the eviction decree has been affirmed up to this honorable court. Now, my lord, they took out an application under order 101, 97 and 101 contending that, my lord, the property is a thiccer property, so decree cannot be executed. That application is pending since 2013 and since 2021, it is fixed for, my lord, argument.
In the case, 59 of 2013.
It is, my lord, if you also kindly transfer the, my lord, I have given the type copy of the order, my lord, inner page 3.
Substitution application.
Yes, yes. Inner page 3, kindly have a look at inner page 3.
Halda substitution application
yes.
expunging.
I am
Has
coming.
that been disposed of? Substitution.
By this time, kindly have a look at page 3.
Page 3 of the
type copy of the order. Order dated 6th March 2021.
6th March. No, Mr. Halda, please kindly come to.
I am coming
the
to
order
that.
dated 19th of March 2024.
Yes, my lord.
Please see 30th of November, it was fixed for hearing of the substitution application.
That's true, but it is in the argument stage. Kindly have the order dated 6th March 2021. 6th March at the top.
Yes.
6th March 2021.
Yes.
Well, I have given my type copy at the top, my lord.
Yes.
Both parties file Hajira. OPW is further cross-examined in full and closed to 20th March 2021 for argument.
Yes.
It is in the argument stage. Thereafter, my lord, the petitioner number 1 died. They took out an application, my lord, for substitution. But in the application, my lord, they have filed, my lord, in the caption, they have written, my lord, right thing. And application for substitution on the date of petitioner number 1. But in the body and then in the prayer portion, they have, through inadvertence, they have stated, the opposite party number 1 died. That is that this is no learned court below has been pleased to fix on the next date. The application for substitution was heard and it was fixed for clarification and order.
What has been done? Has been disposed of now?
Not been disposed of.
Then I have directed the substitution to be disposed of first.
2nd August, my lord, 2nd August of this next month, my lord.
So I'm directing the substitution to be disposed of.
And thereafter, my lord, to dispose of the, my lord, this application.
This application under Article 227 of the Constitution.
number 327.
Madam, for the petitioner, Mr. Ahmed is reading is this matter. my lord.
Lad,
Yes, Mr. Ahmed.
order impugned is lad with the certified copy. By this order, lad, order passed
12th March.
was directed to be enforced, lad, in an application under section 151. There is a specific provision under the Act, section 28A, for enforcement of any order passed under the Act.
No, the opposite parties appeared.
No. This is first time, lad.
First time, my lord.
My salary has been attached, my lad, for enforcement of a order passed under section 24, lad.
Has to be rightly.
No, I'm not on that. Man, there is a provision. This is application under section 151. Whether this can be done or not. I understand this is a welfare legislation. Still, my lad, I am paying 12,000 per month. No difficulty. There is some area dues. I want to pay it. There is no dispute, my lad. Two-way this can be disposed. My lad, instead of going into all those technicalities, if you can ask me to serve a copy, and my lad, so far this attachment is concerned, my lad, let it be less amount than.
So, Ahmed, what is the amount due according to you?
My lad, I don't dispute the amount, my lad.
So what is the amount?
4,58,000, lad.
How soon you will pay that? Please,
Lad, there is
attachment will be.
lad, that order impugned says, lad, 25,000 per month.
Yes.
So, lad, this is in a proceedings which is not, lad, with all due respect, lad, is within the jurisdiction of the trial court, lad. Because it is under section 151, this application, this order was passed, lad.
Yes. Caption is immaterial, Mr. Ahmed. The prayer is material. Court should not go into the caption, but the substance. So you pay the amount, attachment will be lifted.
Lad, that's the direction, lad. Instead of 25,000, can it be some less, some amount less than the direction? Because I am 12,000 I am paying per month.
No, what is your salary, Mr. Ahmed?
My salary is around 9,000 I am receiving. No difficulty. I'm a schizophrenic patient,
Mr. Ahmed, what is your salary?
In hand, I am receiving around 90,000.
Around?
90,000.
90,000. So,
if I'm not mistaken.
Yes, please.
There are others to maintain. Instead of 25,000, can it be 15,000?
Mr. Ahmed, also the wife you have to maintain.
Yes, kindly see, in this case, I don't bargain on this,
Yes.
All this I'm saying because, kindly see.
So you are Mr. Ahmed depositing some amount.
I am, in this is a case, where I got married on 11 February, she left on 12 in the month of June in the same year, after 3 months.
After passing of the impugned order on March 2025, how much have you paid?
I'm being paid. I'm paying it regularly.
Mr. Ahmed, please hear the court, then answer. In excess of 12,000, I am saying. With regard to the arrears, how much have you paid from March till date?
Since the salary has been attached, in every month, this amount is being taken away from my salary.
So let it be taken away.
That's why I am before the court.
Yes.
That's why I am before the court. Instead of 25,000, I am paying 12,000 per month.
Yes.
Can it be 15,000? So far, arrear is concerned. I don't mind, I do not want to dispute whatever has happened to me. I don't want to quarrel on that.
Yes.
In the month of February, I got married. In the month of June, she left. Now, I am a schizophrenic patient. My family members is looking after me. I have some duties towards them. Somebody who had joined with my family for 3 months.
So, Mr. Ahmed, for 3 months, if the wife no alimony to pay.
That's the law I have to. That's the law I have to. That's the some mercy.
That you have also to maintain the wife.
I understand. Ultimately, if the court decides that she left me, it was her decision, then I may not have to pay the money.
Show me the law with regard to that. that if
But in this impasse, the law is against me, my lord. I want some mercy from this court, my lord, so that
sir, there is no question of any interim order, Mr. Ahmed now.
my lord, instead of my lord, paying, my lord, let it be, my lord, pay 15,000 per month, my lord.
No. Without hearing them, it cannot be reduced. If
My
you
lord, this is area, my lord, monthly I'm paying.
yes, monthly you have to pay. Areas also you have to pay. Both.
Can it be some amount less, my lord, than it is directed?
Not without hearing the other side.
As illustrated, please.
And some cost, pay some cost, Mr. Ahmed, for restoration.
My lord.
Why? Restoration, this matter, pay some cost, Mr. Ahmed.
But I have not been paid with the,
After hearing the learned advocate for the petitioner and after going through the averments made in the application, being Can 1 of 2025, this court is satisfied that the petitioner was prevented by sufficient cause for not appearing when the civil division application stood dismissed for default. First of in view thereof, the order dated June 30, 2025 stands recalled. Can 1 of 2025 stands allowed. The civil division application stands restored to the original file and number. First of paragraph. CO order code. The civil division application is taken up for immediate consideration. First of by the order impugned, the application under section 151 of the Code of Civil Procedure was allowed thereby directing the employer of the petitioner herein to remit an amount of rupees 25,000 from the salary of the petitioner to the wife each month till the realization of the amount of rupees 4,58,000. Full stop. Paragraph. Mr. Ahmed submits that the amount which the petitioner is directed to pay on account of area maintenance, area maintenance should be reduced. Mr. Ahmed Laner, advocate appearing for the petitioner, prays for reducing the amount of amount which the petitioner has been directed to pay on account of area maintenance each month. So the petitioner is directed to serve a copy of this application upon the opposite parties by registered speed post with acknowledgement due and file an affidavit of service on the next date. List this matter under the heading motion in the monthly list of September 2025. First up, it is however made clear that pendency of this civil division application shall not. Nah,
97, Expeditious hearing, 197.
197. Din. Should have mentioned it earlier so that the files could be brought in.
I also had one mentioned. 127.
127. So, Doctor, you record should have mentioned.
I had been here, my lord, for some time.
We are shortage of staffs. It's very difficult.
My lord, without the file also, lordship can fix it. I will indicate, my lord, just after this.
Let the files be brought on. What is your item number?
127.
120. Your item number?
197. Expeditious, upgraded 197.
127, 197 the barcode.
My lord, item number 36.
41 and 43.
36.
I have 238.
36.
36.
36 it was called on. Where were you?
Parthasarthi Bhattacharya lead by PAT and he is not available. Senior counsel, item number 36.
36.
127.
So what do you want now?
Tomorrow, if it is.
Tomorrow I do not. 36 has been made.
Item number 238, my lord.
Yes, Mr. Bordon.
Item number 238.
To bring out the files, your advocate of record.
My lord will not have to bring out the files. Will just have to hear me for 2 minutes.
Orders have to be passed on the, unless they.
I don't require orders. I don't require orders. I just need an audience for 2 minutes.
335, can it be fixed tomorrow?
You have taken a resolution and you are moving now. 335.
Yes, my lord.
335 to mark according to 335, 127.
No, 238.
197.
38, 197.
197. Expeditious, short matter. Suit 490.
197. And yours is 127.
127.
No. If you had mentioned it earlier, files could have been brought up. Today there is also shortage of staffs. That's the difficulty.
And carrying an office copy just in case.
Unless the files could be brought on, Mr. Datta, it will be very difficult to put the orders in the file.
127, I will only need one line, my lord. There's a caveat. So adverse, I cannot get anything today.
Caveat, Mr. Datta,
No,
cannot be
my lord,
taken.
adverse, I cannot. Lordship remembers, I mentioned it 4 times. Mr. Surojit Nath Mitra mentioned it once. I only pray for this, but kindly hear me. Is a my lord, dismissal of a order 13A application in a suit for eviction under section 106 of the Transfer of Property Act. Property I mentioned, my lord, it's on VIP Road, Vishal Mega Mart. My lord, more than, my lord, 40 lakhs per, my lord, month it's due. My lord, it's crossed 20 crores now.
But what can be done now?
No, I only pray for this, my lord. We had mentioned also citing this urgency. Lordship has entertained it, but somehow it has not come up. Well, I'll give them notice. Any day Lordship gives me, my lord, directs that to come on a particular day at a particular time. I'll give them notice and then I will move. That cannot be, my lord, adverse to their interest.
120.
27.
When have you mentioned?
My lord, I mentioned it 4 times. Mr. Surojit Mitra also mentioned it once.
Last Wednesday you have not mentioned.
Mr. Mitra mentioned before that, the week before that.
দেখুন তো ওইটা মেনশন করেছেন বলছেন।
Lordship had entertained it.
Have you? No. Have you inquired that when it has been? দেখুন।
127 CO number মেনশন করেছিলাম।
Yes, this is এটা কত নম্বর? 127 নেওয়া যাবে না। Let me see whether it has been fixed or not. Because if you have.
It has not been fixed. Otherwise, my lord, we would have asserted.
Either fixed or rejected.
No.
It has to be. All mentioning slips of Wednesday I've gone through. I've mentioned either fixed or rejected.
My lord, I am only praying for
Please,
this.
see, check up the mentioning slips. Ask your clerk to come.
Even if it is rejected, my lord, I am taking a chance today, my lord. I am only pursuing your lordship, my lord.
Doctor, in the absence of the other side, it cannot be taken up.
My lord, it's not to pass adverse order. I am only praying that the court fixes that it gives me after 2 weeks. I will give them sufficient notice. Only gives me this indulgence to come and move it on a particular day. I am not saying pass any order in my favor.
Supplementary list fixing a date, unless it's extreme urgent,
my lord,
it's difficult.
My lord, at times, my lord, pecuniary, my lord.
Then, Mr. Datta, I will do one thing. I will not entertain any mentioning. I will proceed serially.
I am at your mercy, lordship's mercy.
So, Doctor, then it's difficult because the dates, defense has been struck off, the arguments have been fixed. I'm giving those precedents. If these matters are to be given precedence, then I have to forget everything. I will proceed serially.
But my lord, then kindly visualize this. I, as a landlord, my lord,
Mr. Doctor, supplementary monthly. Please look at the pendency. Please consider that. I appreciate that because it is the supplementary list.
Here, lordship can understand our pain, my lord. At times, my lord, we are
fully appreciate, Mr.
We don't have answers to give to the client.
I fully appreciate, but it's the difficulty. Please look at the number of combined list matters which was fixed for 2 p.m. and Friday it was half day could not be taken up. So those accumulated today also this thing. Tomorrow half day will not be there. So these accumulations.
Any day, lordship.
Please let me see. Let me see the contested application matters. Now it's difficult because supplementary list fixing a date unless it's extremely urgent. I'm not entertaining that. Please ask your clerks to inquire, because some have entertained, have fixed the dates, others have rejected. Please look the endorsement. That's the difficulty.
Suit for permanent injunction, Lordship. Suit in the year of 1994 till date. Issue had not been.
Yes.
Only for expeditious. I am here for the defendant number 6.
What happened to the substitution application? Order 22, Rule 10, what happened to that?
Still pending, Lordship.
Order 22, Rule 10 application is pending. What is the next date fixed?
19th August.
This application under Article 227 of the Constitution of India.
Item 132, if my lord is rising, item 232 of your lordship's daily list is for expeditious disposal, my lord.
232?
232, my lord.
But
the match suit of 2020.
389 na kotha? Yes, Mr. Bordon, what is your item number?
238, my lord.
230, বার করেছেন? 238.
Yes,
What is your item?
232, my lord.
232 টা দেখুন তো, 232.
Lord, 238, my lord, cannot pass any order because of the after service matter, my lord.
Is after?
After service. The problem is, my lord, the problem I'll tell you, my lord. My section 34 has been, my lord, dismissed as not maintainable, saying that it's a commercial cause. Now the learned judge in the court below doesn't transfer it to the commercial court, but keeps it.
Bordon, I can take it up today.
I'm not inviting my lord to take it up. My lord, I mentioned this matter last Wednesday, the Wednesday before last, my lord. The problem is, my lord, taking advantage of this. It's after service, taking advantage of this.
Ask your advocate on record to inquire what has been done in the mentioning slip.
My lord, probably the mentioning has not probably found favor.
Mr. Datta was also there. It's difficult to fix matters.
My lord, I understand, appreciate, but here, my lord, they are creating third-party interest, my lord. The development agreement, my lord, they are creating third-party interest, my lord. Any day, my lord, any day.
Then I have to proceed serially. I will not entertain.
Kindly doesn't do that. My lord, any day, my lord, 2 weeks, 3 weeks, if I can give them a notice that the matter will be taken up on such and such day, my lord, they'll stop for the time being. They're dealing with the property, my lord.
Yes,
they're dealing with the property.
Yes.
But they're dealing with the property. This is the predicament, my lord. I wouldn't have troubled my lord with this. They're dealing with the property in the absence of any interim order, my lord. My 34 returns saying that the court doesn't have jurisdiction, it's a commercial cause.
Yes.
Not any day, my lord, any day subject to loss of convenience, my lord.
Yes, you mentioned on Wednesday, I will consider that. Ask your.
Kindly, Mulot. Wednesday, I will mention myself, Mulot. Kindly consider this on that day, Mulot. I'm so grateful, man. So grateful.
Yes, what do you want? Expeditious hearing of what?
This is a match suit, my lord, of 2021, my lord.
What is the stage of the matrimonial suit?
2023, parties were sent for mediation. That failed, my lord. Thereafter, no progress, my lord, as such.
But mediation report has come. It failed.
Mediation report, but it has been sent according to the order of the last order of 2023. It was sent to mediation.
What happened after that? If there is
Received
no
report 4th January 2024. It says received report from mediation kept with the record. It has failed.
It has failed.
It has failed.
Thereafter, what is the next date fixed for what?
The next date thereafter effective hearing has not taken place, my lord. Dates have been it has been adjourned now and again.
You have a copy.
Let me I hand over.
পাওয়া গেছে? So this miscase was for alimony.
Miscase is for alimony that has been disposed of. My lord. A revision.
When it has been disposed of?
Recently, the revision petition has been preferred therefrom. It is supposed to appear day after tomorrow, my lord, before your lordship.
This application under Article 227 of the Constitution of India